Cameras on, everybody stay on mute. Cameras on, stay on mute. Welcome back, guys, to part 4 of the Kitchen Court Divorce Cases saga. Please hit those like buttons as you come in the door. That's how we take attendance here. Feel free to lurk if you're not feeling well. I'm sorry. Oh, damn it, so close. Mute. Cameras on, stay on mute. Welcome back, guys, to part 4. I got really good at doing that, but now I'm not good at that anymore. Anyways, we are going to continue with our divorce saga. If you're new here, this is part 4, but we'll catch you up if you'd like to stay and hang out. If you want to go back, all the other videos are linked in the description. We are we've only really heard from lawyers and witnesses, and the dad just finished his direct testimony, and we are now waiting for the cross-examination from attorney Zoglio. And you're going to notice a lot of kegs going up in the chat because this attorney is obsessed with the 5 beers that this guy seems to have had in his life. They have talked about virtually nothing else. Anyways, let's continue. We'll get into it. I am drinking some iced coffee that's called Blue Mountain Blend from a can. But I'd love to hear what else you guys are drinking. Okay, let's go, guys.
Sir, you just made a statement that Oakley lives in hotels.
I did.
You did, yes, sir. Can you tell me which hotel?
I sure can. I got them listed right here.
And when?
Okay, so this is all that I could figure out from the text and stuff. So I know there's more, but these.
Hold on. No. Listen, guys, I'm just trying to figure out YouTube Daddy, and YouTube Daddy doesn't like addresses on YouTube, so I am going to put this guy on mute to see what he says. If he's listing out the literal address where this child is purported to be living, then I'm gonna have to mute that out. But I will overlay with a funny stereotype about the type of hotel or motel and see if you can guess which one it is. I think that's a fair compromise. Okay, he's not even that. First of all, objection, Your Honor. What are you referring to right now, sir? Are you looking at notes? I would be objecting. But I'll even go back. This is stupid. He's not even saying where she's staying. First of all, you took note. Your notes suck, dude. Anyways, let's continue.
Keep her vegetarian. It's her choice. I'm not her.
You just been in hotels.
I did.
You did, yes, sir. Can you tell me which hotel?
I sure can. I got them listed right here.
And when?
Okay, so this is all that I could figure out from the text and stuff. So I know there's more, but these are the ones I know that I have on proof of text. 9/7 of 22, Heather took her to her Jackson office. 10/3 22 to 10/5 22, she took her to the state of Indiana, and her mom watched her at a hotel. 9/19 of 22, this is New Era, Michigan. Kellogg Center in Lansing, Michigan on 9/29/22. Grand Rapids on 12/5/22 to 12/18/22.
Hold on. Give me those dates again.
I'm sorry, I said 18, it's 8, 12/5/22 to 12/8/22. Apologize.
Okay.
She went up to Paradise on Superior on 1/22/23 to 1/4/23. For MSU, she was in Traverse City on 1/16/23 to 1/18/23. Benton Harbor, 21/23, or sorry, 2/1/23 to 2/2/23. Back to Traverse City, 2/8/23 to 2/9/23. Back to Paradise. Our restaurant is shut down now. So 2/28/23 to 3/1/23.
Okay. And so, sir, have you ever taken her to a hotel?
The only hotel that I just took her to was when we went to the state's largest aquarium in Chicago 3 weeks ago.
So she would only stay there for a couple of days, just like you only stayed there for a couple of days, right?
Yeah, but it was for her entertaining, taking her to the aquarium and all the museums, and it was for our daughter directly.
Is it true that she likes to stay in hotels at times?
No, I've had complaints from her about bouncing around in all these hotels.
You've had complaints, okay.
Does like the pools though.
Yeah. What about the Chicago hotel that you spent with her? Where was that?
I mean, I don't have the address on the top of my head, but it was right by Lake Michigan. It's right next to the aquarium. Look up the aquarium, the big states, the U.S.
Okay. So she doesn't exactly live in hotels. She's been to some, but she doesn't live there. Right? Is that fair to say?
That's the way you want to put it.
I wanted to ask you something here before I start getting into some other topics, sir. You said the biggest problem that you have is no communication with Heather.
Correct.
All right. Recently, your council sent over a large amount of text messages. Okay? I'm holding them up right here.
You betcha.
All right. And you also said that during your that she's not willing to cooperate with you. She's not willing to compromise with you about things. Is that accurate?
It is. I don't get notification until she's there. I would respect a couple 3-day notification, or even a 24-hour notification.
So if I were to go through these thousands of text messages and read you some of them, would that refresh your memory about her willingness to work with you and changing days?
I read them every day, but I know exactly what you're reading.
Okay. So is it true that and some of these text messages that she's saying to you, call me, and you talk on the phone? Is that true?
That she says call her?
Yeah.
I don't know. I'd have to see a couple. I mean, it might be a couple in there, but it's not rare.
Well, I don't expect you to have these text messages memorized, but I'm looking at thousands of text messages here, and you've just testified the lack of communication that you have with her. But yet there's, like I said, thousands of text messages. Do you deny that?
The part that you don't understand, sir, is that if you look at the time frame could be a day and a half before I get answered. Just like yesterday, I talked about trying to get her a little, because I didn't have her for Easter, so I wanted to get her early on Wednesday. Well, it took her hours and hours to get back with me, and almost the next day. When I know she carries that around 24/7, she works at home. She has that phone with her 24/7.
Okay. But I'm looking at other text messages here about her communicating with you and switching days. And I think you also testified, sir, that she actually has given you more time. You've texted her and asked her, and she's cooperated and given you more time.
I've already agreed to that. I appreciate she gave me two times. She's given me some extra time. That's why I was asking for this Wednesday so I can have a good Easter with her.
Let's go through a couple of these because I don't want to take up an entire day here, sir. But let's go through a couple of these, okay? On 12/8/22, do you have the text messages in front of you, sir?
It's probably easier for him on his phone to find them.
Right. Can you look up 12/8/22?
Yes, I can. Almost there, bud. Okay.
Sir, and I appreciate you looking that up on your phone. Could you please just kind of keep that up? Because I may ask you about some other ones too without going into hundreds of them. But I'm looking at 12:11 p.m. Did you want to see Oakley early today? 12/8.
So December 8th at 12:11.
Well, yes. No, yeah. December 8th at 12:11.
I got 12:11. Did you want to see Oakley early today? Yep.
Yes.
And then it does. Yeah, but here's what I'm trying to get to you.
I'm just asking you.
I'm trying to answer.
Sir, just answer the question. Don't go and assume what the next question is going to be.
So that was at 12:11 p.m., correct?
Got it.
All right. And you actually liked it at 1:24, so over an hour later, right?
Heather liked it. That's Heather. You're on the wrong page, bud.
Did you answer her?
I did. I said I'm working. Can you see that on the printed form? That's my point. She tells me when I'm right on the spot when she knows I'm working. It's a trick.
It's a trick.
Yeah, don't you work at 1:18 p.m., sir?
Sir, I'm trying to ask you these questions and you keep interrupting me by trying to ask questions. I mean, the way I'm seeing this, it looks like she asked you at 4:25, are you near? And you said, I'm here. So that was on 12/8?
Yes, it was.
When did you respond on 12/8 back to her? When she asked you about working?
When she stated she's working?
Yeah, because I don't see a response here, sir. She says to you, did you want to see Oakley early today? When did you respond?
So she sent that at 12:11 p.m. Do you want to see Oakley early today? And I responded at 1:18 p.m., which was just under an hour. I'm at work, or I'm working. And then she liked I'm working.
Okay. But she did offer you early time, is that right?
Once I was at work, yes, she did.
Okay.
Now, if it would have been the night before, I could have sent my crew out and been there. I can't just drop what I'm doing, a big mess in the yard, a tree laying down, and go, I gotta run now, boys.
Okay, fast forward to 12/21 of 22.
12/21/22. Okay.
All right. So she texted you and said yes, or if you are in Lansing for some reason, you could come pick her up a little early. But I'd just like to get her home no later than 8:30. And then you texted back right away, Kay, right?
Yep.
All right. So right there, she's offering you early time. Is that right?
Right at the time, if it's not a day early, that I can make arrangements to do that. I'm already at work. I already checked in.
I'm just saying, you're saying there's a lack of communication. Let me go through a couple. Let me go through a couple more of these. On 12/21, hey, if it's the same difference for you, could we stick with the meeting in Charlotte? I could get there by 3:30 if that would help you. I should have actually looked at my calendar before trying to come up with a new arrangement. I forgot my afternoon meeting and I don't want to be driving the whole time if that can be avoided. Did you respond to that?
I did. 3:30 Charlotte.
All right. So again, she's trying to give you an accommodation. Is that right?
I have.
And asking you, to be fair to you, asking you to accommodate as well, right?
She's asking me to adjust my time because she's going to be there early. So she's asking me to get there early because she's sitting there a half hour waiting for me to get there at 4. So she doesn't want to be here for a half hour doing nothing. She wants me to take their daughter so she can.
So, but my point is that she's offering accommodations for you. Is that right?
I don't think so. It means that I have to change things when the scheduled time is 4 p.m. Then I have to change things up and hurry things up, and it makes it more difficult because now I have to go by her schedule, not my schedule. That I already had.
But what I'm saying, okay, but you're going by. I'm not asking you about your work schedule. I'm asking you if she's offering accommodations. Regardless, if you're working, you're working. I understand, but I'm not asking you that. I'm asking if she's willing to, if she's been willing to. You're the one that testified there's no communication, and she's unwilling to make accommodations at all. So I'm just asking about these.
I think that's false. That's my answer.
So she never is trying to give you accommodations.
No, it's to help her in advance. It's to help her so she doesn't have to wait. Our schedule was 4 o'clock, and that's on paper, not 3:30.
Can you go back to 12/21 of 2022 at 8:47 p.m.?
Got it.
You guys are having a discussion about winter boots, right?
I don't know. I haven't read it yet.
Okay, please take a minute to read that.
While you do, thank you, Time Serve, for that lovely, lovely super chat. Everyone, please go hit that
Can you
like
look at
button.
her?
That's how we do attendance. Mr.
Text message
Zoglio,
she
shut
sent to
up.
you at 8:47 p.m.
I am. It's pretty long. I've been busy reading it, sir.
Okay. Let me know when you're done.
I will. And what is your question?
So my question is, the first line of that says, please don't take this as me scolding you. Just trying to communicate. I had sent Oaks medicine and her toothbrush and jammies to try to help her with evening transitions. Wednesday nights are really hard for her because she falls asleep just about as we get home, and the process of getting her out of the car wakes up and disrupts her rest. Plus, she consistently skips brushing her teeth on Wednesday. And in order to keep her from sleeping in her underwear and clothes, and then there's a parenthesis, something the doctor said not to do with her. It goes, I have to wake her up and put her jammies on. I just thought maybe we try a different system to make it easier to retain a bedtime routine. On the way home, and I can't say the rest because it's what she said. Okay, what was your reaction to that?
Well, my reaction to the 3-hour visit is that she wants me to prep her for bed and not have time with her.
I'm talking about what was your reaction about after the text message? What did you say? Did you say I didn't give her any medicine?
Yeah, I did say that.
All right. Do you see that part of the text that she sent in there that said just trying to communicate?
I did see that.
Thank you. Has there even been text messages between you two where you're talking about the road conditions and she's telling you that she's concerned about the road conditions, but she's still, and you're saying, glad you made it safe and that kind of thing? Do I need to go through those or did that happen?
I guess you'll have to tell me about them.
Okay. Looking at 12/28/22 at 9:13. Let me know when you're there.
Got it. What's your question?
My question is, she says to you, just got off the highway on M50, pulled over at Myers to text you back. Roads are absolutely fine, dry, all is well. And you responded, Kay, glad you're safe, right?
I did.
That's good communication, isn't it?
That was a question.
Every question is answered here. I mean, I don't know what you're getting at.
I'm just asking you to answer the question. That's good communication, is it not?
I guess it is.
Can you go back to 12/14/22?
All right.
Look at 10:55 a.m. Let me know when you're there.
I'm reading it right now.
Okay.
Okay.
So Oaks has been having to pee a lot. So I called the doctor to see about getting her check on a urinary tract infection. They want her to stop by and provide a urine sample. It's not a doctor visit, just a lab visit. Do you have any issue with me taking her today to provide the sample before you pick her up? And then you say, if you hurry, I'm on my way now. Do you see that?
I do.
Isn't she telling you ahead of time about Oakley's problem and trying to address that?
Well, we've been talking about that personally way before this, but yes, she did tell me she got an appointment.
All right. So on 1/9/2023, you asked about dance class. Oh, no, excuse me, you didn't. Can you go to 1/9/23 at 6:56? At 6:56 p.m., sir.
You said 23, correct?
Yes, sir. At 6:56 p.m.
Okay.
All All right, FYI, Oakley's Ballet and more dance class starts this Thursday. Number 106 Dance Room, Foster Community Center, 200 North Foster Street, Lansing, Michigan. FYI, same rules as before. Adults aren't allowed in the room. You see that text message?
I do.
You didn't respond to that text message though, correct?
Looks like I didn't.
All right. Would you agree with me? Would
I already
you
have,
agree? I'm sorry, go ahead.
I already had the address. It's stored on my MapQuest.
Okay. But would you agree though that that was done in advance of the ballet class?
Thursday, Monday. Yes, it was.
You also testified about how you don't have an agreement on food.
On what?
You don't have an agreement on food and diet.
Correct.
You talked about how, she likes her pasta and spaghetti. But you got explanations for that. You've had discussions with her. If you could look at the text message dated sorry, there's so many here. I'm trying to do this, but I don't want to go through every one of these. This text message would probably be on 1/11, 2023 at 6:41 p.m.
I have 6:41,
Yep.
8:08 p.m. or a.m.
PM, sir.
All I have is 6:41 p.m. and 8:08 p.m.
Okay, I have a 6:41 p.m. 38 where the text message starts. She got it from her intelligent little brain.
Yeah.
All right. And you're and there's some things in there about what the little girl has supposedly said, and I don't want to get into what Oakley said. But isn't there a discussion in this text message about Heather's feelings about the diet and what she wants her to eat and what her thoughts are?
That's her opinion.
Okay, I mean it's a rather long text, and that's fair. It's her opinion. That's fair. But did you actually respond to that text message?
Honestly, I'm not going to respond to a made-up imagination. I don't have time for that.
Okay, so is that a no? You didn't respond to this text message?
The
6:41 p.m. You did not respond, correct?
I did not know.
And even though you call this imagination, it's still communication in her opinion. Just like you testified before, it's her opinion, right?
I'm just not going to argue with her, sir.
Okay.
I don't agree with what she said, so I don't have a reason to argue because nobody wins.
Well, but you would agree, sir, that that's different than not communicating, is it not? If you don't agree with somebody,
I do disagree.
respond, but that's different than not communicating with them. Would you agree with that?
You're looking at my response to her. You're not looking at her response to mine.
Okay, so again, I would move to strike the answer as non-responsive. I just asked that even though you don't agree with that, it's still communication, correct?
If that's your opinion. I take it as it's an order of something for me to do.
And I think you testified that I think you testified too that she did call you and get your consent prior to enrolling her in preschool, correct?
Yeah, because that's a law. She has to do that.
That's the law. She has to do that.
Correct.
And so you think that's the only reason why she did that?
Correct.
Because it was the law? Okay. What's your typical day like at work?
8. Well, if it's in the summer, it's 7. If it's in the winter, it's 8 to 3 or 4 p.m.
And you're in the tree cutting business, right?
Higley's Tree Service.
Okay. Right. And when you get done with work, do you usually come home?
Correct.
When is the last time you had a drink of alcohol?
The last time I've had a drink?
Yes, sir.
I mean, I can't give you a date, but a week and a half to 2.
And where did you drink?
Grand River.
The Grand River Brewery?
Yep, because I had a ride home that night, so I had a few beers and got a ride home that night.
Okay. So you were too intoxicated to drive home or just playing it safe?
I did not state that at all.
Okay. Tell me again. You said you had a few too many drinks, so you got a ride home.
I
Is that
did
what
not.
you said?
I did not say that.
Okay, tell me what you said. I'm sorry.
I said that I went down there that night because I knew somebody that could give me a ride home. I did not say anything of how much I drank or what I drank.
Did you get a ride home?
I did.
All right. Did you drive there?
I did.
And you did not drive yourself home?
Correct.
And you did that for a reason, correct?
I did that because I'm a citizen of America and I have a right to choose what I do.
Did you do it partially because you were, besides being a citizen of America, did you do it because you didn't want to get pulled over for drunk driving?
That's incorrect.
So you drove yourself there and had someone else drive you home?
For the second time, that's correct.
Okay. And you did that because you were an American citizen? That's your testimony?
The second time, that's correct.
Okay, thank you. Sir, after Oakley was born, did you go to lineman training?
I did.
And where was lineman training?
In New York.
And how long were you? Is it true that you were gone for 4 months?
No, it's not.
Okay. How long was lineman training?
The course was 4 months, but I was not gone. I came home every other weekend and I had 3-day weekends. So I flew home every other weekend for 3 days.
So you flew home every other weekend for 3 days?
Well, besides that, Heather met me halfway, I think twice. We drove halfway and got an Airbnb and spent the 3 days at Airbnb. So we could
okay.
Time.
But during the time you were gone for the 4 months, besides the every other weekend, who was watching Oakley?
Heather's mom moved in. Well, she actually moved out of my home and got her own place in Jackson, which I was against. And then her mom moved in, like she's always moved in. She's always moved in all the time, so it's nothing new.
Moved in where? Moved in your house?
Into the house in Jackson, which was also upstairs.
Again, I'm gonna object on the grounds that you're not answering my question. Who watched Oakley while you were gone for lineman training for 4 months?
Heather's mom did while she was at work, like she does now.
So if Heather's mom, are you saying that Heather's mom watched her full time? Is that what you're saying?
Well, while she's at work and whatnot.
Okay.
Who
Now
else?
that's, but who else besides Heather's mom was watching Oakley? Who was responsible for Oakley while you were gone?
Oh, Heather was.
Did you become a lineman?
I did not.
Were you just going there to do the training for future, or?
Well, I had reason to become a lineman, but then when I got back and she moved out and I felt like she left me, because the whole reason I did it was because of her request. So I went and spent 25 grand on it. And then I come back and realized that she was leaving me and I didn't want to lose my business I had for 26, 27 years. If she was going to leave, I was doing it all for her in Oakley, and I could tell she was already leaving me. So that's why I did the time.
When was this lineman training in New York? Can you give me a time frame?
I was January, February, March, April. It wasn't last year, but the year before. So it's been 2 years. It's been 2 years now, just over.
And how old was Oakley when you left?
2.
2? Thank you. So it's your testimony that the only reason why you left and went for lineman training was at Heather's request. Or was it partially for you?
Heather didn't want me to cut trees, so I agreed to go be a lineman.
Okay. But Heather didn't want you to leave for 4 months straight, did she?
I don't know if you heard me, but it was Heather's idea for me to switch jobs. And the only place I could get into was into New York. We had days and weeks of conversation about this.
Okay. You involved in a pool league?
No, sir.
Okay. When's the last time you were in a pool league?
I've already answered that. 17.
Were you involved in a golf league?
Yes.
Are you still involved in a golf league?
Golfing isn't back in season yet. I haven't joined anything yet.
Okay. Did you golf last season?
I did when I wasn't injured. I missed most of it because I think I golfed the last 3 weeks because I was incapable of my injury.
All right. There's been testimony that you had kept a keg in your house, and you just affirmed that, correct?
In the past, I did have a keg in my house.
When did you first put the keg in your house?
I'm guesstimating maybe 2016, 2017, maybe somewhere in that.
And when did you take it out?
When I realized I couldn't drink without getting a migraine.
So that would have been after your accident, correct?
When I,
All right.
pretty much as soon as I got home from the rehab and everything.
Okay. So would that be sometime in 22 then? Because your accident was 6/2 of 22.
Correct. It would be 6, 7, end of July.
End of July. Okay. So from 2016 to the end of July of 22.
I mean, it might even be a little bit into August because, yeah, I think it might even have been the end of August because I didn't even go down there to drink ever because I didn't even leave the house. You know, I wasn't capable of. So it might have been a little later by the time I got up and moved. And
So you didn't leave the house. When did you not leave the house?
well, Lewis took care of me for the months
2 months.
after I got home from the hospital.
And then after the 2 months, you started drinking again, correct?
It's not correct.
Oh, okay. When did you start drinking again?
I don't call it drinking. I went and had a beer. I got a headache, and the beer was pretty much flat from sitting there while I was in the hospital. So I took it back, got my deposit back, and got rid of it because I got the headache from drinking the beer.
Okay.
I'm not going to heat or pay to run a kegerator when I don't drink it. It's kind of stupid.
All right. So I'm going to name some places, and you tell me if you during the time that either she was pregnant with Oakley or during Oakley's life, if you frequented these places. The Grand River Brewery,
Yes, we attended that.
the Dark Horse Brewery,
I refuse going to the Dark Horse, so that's false.
you refuse to go there?
Yeah, I don't like the Dark Horse due to the ownership.
Okay. When's the last time you went to the Dark Horse?
Couldn't even tell you, sir.
Isn't it true that you just went there on 11/25 of 22?
Not that I can remember.
I'm looking at your counsel submitted to me a discovery request from our Huntington Bank records.
Okay.
Says that there's a visit there on 11/25 of 22 to the Dark Horse Brewery.
Okay, maybe I did attend there one time.
Okay. How about the Copper Pub?
Copper Pub, I have attended there.
How about Cascarelli's?
I love their pizza. That's correct. I've been there.
Okay. How about We Are Saints Again?
That's when I watch my friend playing on his league.
Okay. And that's a bar, correct?
Yes,
How about the Bogart Theater?
I haven't been there. Well, the last time I've been there was with Heather.
Okay. Where's that located?
Right downtown.
Did you go to these establishments after work?
Oh wait, sir, I forgot. The Bogart Theater. I took Oakley there. I did take Oakley there to watch a movie. You're right. Sorry. That's how much I go to the Bogart Theater.
All right. Okay. So did you frequent these establishments in the months following your accident?
I have.
How often do you think you went to the Grand River Brewery after the accident?
I like to go there on Mondays for the half off of the food. So I probably went a couple times a month on Mondays to the Grand River.
Okay. And did you get anything there besides food?
Like my friend stated, you have to buy a drink there to do it. So I have, until I learned that I get headaches from it, I did buy a couple beers there, but I've also bought Pepsi there. And I've tried his fancy drink he told us earlier. That's non-alcoholic.
Okay. So is it true that you attended the Copper Pub on 10/25 of 22, 11/18 of 22, and 11/23 of 22? Well, does that sound right?
I guess if you're reading it off my statement.
Yeah, and that's where I got these, your statement, but you're free to check and dispute that if you want, sir. And that you attended We Are Saints again on 2/10 of 22 and 11/25 of 22.
Okay, if that's what you're reading.
And you attended Coscarelli's on 1/27/22, 9/22/22, and 10/21 of 22. Is that right?
I don't know about that. I've been to Casparelli's like twice since we've separated.
Okay. Do you need to refresh your memory by looking at the statement?
I would like to, when this is over, I might have to.
Okay.
Actually, is there a time on that? Because I did, when I worked for the owner of the Sitgos, I always take my employees there for lunch. Does it say the time of that? Is it near, between noon anywhere, like 11 and 1?
Sir, I'm not going to respond to your question. I'm sorry. I'm not going to respond to your question. And you don't need to laugh at me, sir. It's not appropriate for me to answer your questions. That's why. Is it true, sir, that you attended Grand River Brewery on 1/12 of 22, 1/27/22, 2/3 of 22, 2/9 of 22, 4/13 of 22, 5/2 of 22, 5/25 of 22, and then again on 9/1 of 22, 9/6 of 22, 9/13 of 22, and 11/4 of 22. Is that fair to say?
I don't believe so. I think you're looking at that credit card. That's not mine.
No, sir. I got that from your Huntington statements.
If it's on my Huntington, then maybe I did. But if it's that credit card, I didn't.
Yeah, I'm not talking about credit cards. I'm talking about what's in your statement from Huntington Bank that your counsel gave us per discovery request that you supplied. Is that accurate?
If that's what you're reading.
On 9/1 of 22, 9/6 of 22, and 9/13, that is about 3 months after your accident, correct?
Correct.
Okay. Okay. Is it true, sir, that you attended three times? Were you drinking alcohol during these periods of time at the Grand River Brewery?
What 3 times are you talking about?
9/1, 9/6, and 9/13 of 22.
9/1, 9/6, and what else?
And 9/13 of 22.
I don't know what I had. I didn't drink alcohol 100% of the time. I know that. Just because I don't have someone cooking me dinner doesn't mean I'm an alcoholic and I go out and eat.
That wasn't the question, sir, but is the answer to your question that only some of the time you were drinking? Is that what you're saying?
Correct.
All right. Is it true that you drained your keg at home actually at the end of September of 22? You drained the keg then?
I don't drain kegs. I took it back because I have a deposit on it. So I took it back for the deposit.
Okay. Hold on there. Can you tell us when you started living with Heather?
Mr. Glad, how is that relevant? I mean, the issue today is custody. It's not anything that's happened before the child was born.
I can rephrase, Your Honor.
Thank you.
During the time that after the child was born, did you participate in a golf league?
I have.
Did you drink alcohol at the golf league? Is that yes?
Yes.
Okay. In golf leagues, the beverage cart girls come around and they give you alcohol, correct?
Incorrect.
Oh, where did you get the alcohol at the golf league?
When we pay our dues to golf and for the golf cart, we get a 6-pack and split it in 18 holes, which takes about 4 hours.
Did you? Is it true, sir, that during Oakley's life that you purchased University of Michigan football tickets?
Correct.
And how much were those?
Your Honor, relevancy?
Relevance?
Your Honor, I think there was some testimony about what he makes, and there's also some. We have the tax returns and the profit and loss statements of his business, and if the court will allow me some leeway, I can tie that in.
I can define all of that.
And it's also relevant to his ability to financially take care of his daughter.
I don't see how buying football tickets has a relevancy to how he can take care of his daughter, sir. I'm going to sustain the objection.
In your profession, sir, do you do storm work?
Yes, I do.
Okay, what's storm work?
Storm work is when Mother Nature has caused a limb to come down, like snow, ice, wind.
And people rely on you to do storm work, correct?
Well, that's what I have a tree service for.
Okay. And when you and Oakley and Heather were together, did you have storm work?
I'm sure I've had some. I could look it up and tell you the exact stuff on the computer if you want.
Okay. No, I'm not asking you about that. I'm asking if you had some storm work.
Of course I have.
Okay. And while you were at your storm work, who was watching Oakley?
Heather. Or it could have been my mom. I mean, you have to get more specific on the dates. She has different people to watch her at different times.
Okay. And after so it was either Heather or your mom? Is that what you're saying, depending on the time?
It could have been Heather's mom. They could have been at my cousin's house. They could have been at her cousin's house.
Okay. Did you ever leave to do storm work with Heather watching the child after you left?
Well, when a storm hits, it takes months to clean it up. So
Yes or no?
Hours.
Yes or no?
Can you rephrase the question? Because I'm not sure I understood it.
Did you ever leave Heather and Oakley together and while you went to do storm work?
I guess, if that's the way you want to put it. I do that every day. I go to work every day. I have to work 8 to 5 every day. 8 to 4 or whatever.
Going back to the University of Michigan, I'm not going to ask you about the tickets, but I do want to know, did you tailgate before the games?
I don't tailgate.
Okay. Did you drink alcohol before the games?
Sometimes it depends on if I can get there early, or it depends on what time the game is. You have to be more specific on on each game.
Okay. For the home games, did you often drink before the home games that you attended?
You're gonna have to get specific more on each game.
Did you ever drink at any of the home games?
I have.
Which games did you drink at, and which games did you not drink at?
Most of the games start at noon, and I don't drink till the afternoon, evening. So anything that starts at noon or 3:30, I don't have time to get there and blah, blah, blah. It's very rare. They just opened it, 2 years ago to have night games, and they usually have 1 or 2 night games. And those are the only games, 1 or 2 a year. And those are the only games that I have enough time to get there and like tailgate.
Okay. But for the away games, you don't go to the away games, correct?
Not really since Oakley. Before Oakley I did, but not really since Oakley.
Okay, but since Oakley, I think you testified that you would have people over to watch the game at your place, correct?
And not all the time, but from time to time.
All right. And you had your friends over and you had the keg going at that time, correct?
Before the accident.
You've made the statement that you want 50-50 custody, correct?
Well, if that's incorrect, there's some other term
Okay.
that I would like added to that.
All right. I think you also said you wanted full custody. Is that true?
That is true.
So what's the circumstance that you want 50-50 custody versus full custody?
If she will move the 5 blocks from me at her house she already owns. And
So go ahead.
and I forgot what's your question now. You interrupted me.
So you're saying that she can have 50-50 custody as long as she lives close to you, correct?
Yeah, if she can attend the local school and we can live in an area together where each week we can swap her, I have nothing against it. I want Oakley to spend time with her mom too. I don't want to take her from her mom. If she chooses to move away and it's her choice that she left our local spot, then I feel that I should put her where she knows people, where she has friends at this school, where she plays with these people, where she's used to being. Why?
Okay. Well, you've already testified that right now she's in a preschool, correct?
Correct.
All right. So am I understanding you correctly that 50-50 is appropriate if she lives by you?
Correct. I'd be glad to.
And it's inappropriate if she lives away from you. Okay. If you get 50-50 custody, are you aware that you're going to have to possibly give up some things?
You name it, I'll give it up.
All right, I will. How about going to the bar?
It's no problem there. I don't go to the bar anymore.
How about golf league night?
I could.
You don't go to the bar. You just testified you did go to the bar.
I have no problem. I don't really go like I used to. So if
Okay.
it's
How
not,
about golf league night?
I don't have a problem with golf league.
Okay. How about University of Michigan home games?
Well, I
They
don't go.
play,
I don't-
play on Saturdays, right?
That's correct.
Would you be willing to give that up if you had 50-50 custody, or would you, if you were required to? Would you give that up?
I don't know. I keep trying to answer here. Can I answer?
Go ahead.
Yep. I already sell all of my tickets anyways to get money to pay for the next year. So I only go to like 2 games a year. I don't feel that if she gets her on a weekend that they have a home game, there's no reason that I shouldn't be able to go. If Oakley is with Heather on that weekend, I will promise you I won't go the weekends that I have Oakley in custody. That's already sold on StubHub. At the beginning of the year, I'll figure that out, and those are all going on StubHub to sell.
Okay, so you're willing to sell your tickets on the days that you have her, correct?
Yeah, that's what pays for my tickets every year is selling them on StubHub.
And I think you've also testified when your counsel asked you that you're also willing to do alcohol and drug testing to prove that you're not drinking while she's in your presence. Is that true?
Name the time and place, I'll be there.
Okay. And you've also testified that you don't drink with your daughter around. Is that what you're saying?
Never.
All right. But when you were living with Heather, your daughter was around, correct?
Correct. Once our separation hit and my accident at the same time, she left me with the day I got my accident. So that's June 2nd.
I thought she moved. I thought she moved out in September.
Well, she moved up north. Remember? We went over this earlier.
She moved up north. Okay. But I think you had said that there's testimony that Lucky took care of you for 2 months, right?
Who else is gonna? Heather's not there. Oakley's not there for me to spend time with.
Hold on, sir, you're not answering the question. Just answer the question that's asked.
Let's make it simple here. Isn't it true that Heather and Oakley were living with you when they were living with you? You had a pattern of drinking, correct?
That's incorrect.
All right. Do you remember March 16th, 2022?
Not off the top of my head.
If I were to tell you that you came home from Mike's place to play pool and you stumbled home drunk, do you remember that?
What was the date on it again?
March 16th, 2022.
I remember the incident, but I don't remember stumbling home, in your words.
So you weren't drunk that day?
Not in my opinion, no.
How about March 18th, 2022? You came home intoxicated after playing pool. You remember that day?
I don't have it registered in my head to remember that. No, I mean,
All right. How about March 19th, 2022? You came home at intoxicated at 7:45 a.m. Do you remember that?
I never come home in the morning like that.
So is that you can't remember or you don't know?
I find it hard to believe because I come home at night. I don't wait till the morning like that to come home.
How about March 20th, 2022? You came home drunk.
No.
How about April 12th, 2022? Were you drunk in your shop with your friends?
Again, I don't remember it over a year ago.
Who is Moomies? What is that? Are those people?
It's a guy that I used to hang out with. More likely now, our daughter hangs out with his daughter. But he went through a separation, so we communicate with his daughter's mom now.
Do you remember being drunk at his place on April 12th, 2022?
I don't. I never went to Moomies.
Do you remember April 25th, 2022? When you became so intoxicated that you told Oakley you're not her dad anymore?
That's imagination. I would never say that to my daughter.
You deny that then?
Correct.
All right. How about September 3rd, 2022? Do you remember Tim Esser giving you a ride home?
I do.
And didn't he give you a ride home because you were intoxicated?
That's correct.
When he came up to the window, okay, let me ask you this. So September 3rd, 2022 is just about 3 months after your accident.
You bet.
Okay, sorry, I had to count. I'm not a mathematician. So you were in your mother's house. I think she had passed away since that time. And you were over at the house, correct?
Kind of, sort of.
And you were in your car when Mr. Esser came up to you?
I was not.
You weren't in your car with the engine on?
I was not.
Okay. Did Tim Esser offer you a ride home, or did you ask him for a ride home?
Nope, he came over, walking over to me and offered me a ride home.
So you were clearly intoxicated on that day, correct?
Correct.
Is it true? I think you testified about an accident that you were in on May 3rd, correct? Where with a construction barrel?
Correct.
Is that the time you drove to Indiana?
That is the time I drove to Indiana.
Okay, why did you drive all the way to Indiana?
With my parents passing away, I couldn't sleep, and I just wanted to go for a drive and just maybe play some music because the Heather and Oakley were sleeping, and just to get my mind off of it. And I drove down there, and that's when I seen the deer and hit that barrel and swerved to miss that deer on I-69.
Were you? And I think you testified that you were not intoxicated at that time, correct?
I was not. I had a beer and a half that night watching Matt play pool, and then he lost and said he's leaving. So I said, if you're not here, I'm leaving too. And then that's when I hit 66 South to go to Indiana. I didn't have like a spot I was going. I was just driving.
Okay. So you had a beer and a half this particular night.
While he played his 4 pool matches.
All right. Refresh my memory. Somebody testified already that you were a .03. Was that you? In some accident?
We had it here somewhere on paper, .036 or .03.
Okay. Well, I'm not trying to trick you here. I just want to know, sir, when was that incident when you were .03?
That was the motorcycle accident.
Okay. Thank you. Do you ever go to Mike's Bar?
I don't.
Okay. Is it true that you're not allowed in Mike's Bar?
It is true.
All right. Did you get into a fight at Mike's Bar?
I did.
And who did you get in a fight with?
I don't even know the guy's name. It's so long ago.
Does he have a nickname?
I don't ever go there, so I didn't know him.
Can we clarify whether this is before Oakley or after Oakley?
Okay. Do you know when that was? Do you know when you got into a fight in a bar? It was after Oakley was born, correct?
And it was quite some time ago. I can't give you the exact date, bud. Sorry. It's
okay. If I were to tell you it was 2019, would that be accurate?
I think I informed you. I don't know when it was, sir.
Okay. Was alcohol involved in the bar brawl?
Yeah, we were both drinking.
What caused it?
You want to hear this weird story? Sure. So I was playing pool, and a kid walked up to me and said that he wanted to play this girl because if he beat this girl at pool, she would have sex with him. And I laughed and said, way to go, bud, but to be able to play pool, you got to put your name on the chalkboard and your quarters on the table, and when it's your turn, you can try to beat me. So then he threatened to kick my butt, and I went up to the bartender, and I told the bartender that I just was threatened. And then the bartender was like, yeah, I'll be right over there. And then so I put the quarters in, played the next game, and he came up to me threatening me again 3-4 times on the next game. So I went back up to the bartender and said, he's really on me now, and he's kind of bumping into me while I'm shooting, blah, blah, blah. And it's going to happen. And then the game ended. I was down on my knee putting quarters in, and he attacked me.
Okay.
That's when I defended myself. And we both have been banded from there ever since.
All right. Is there any reason why you didn't just walk out?
Why I didn't walk out?
Yeah.
I just enjoy playing pool. I don't get out that much, and I just want to finish my game.
Okay. So is it true that you've never done any? You testified that you don't have a problem with alcohol. That's your testimony, correct?
Correct.
All right. So you haven't done any Alcoholics Anonymous or any treatment?
No, sir.
Your earlier witness said that he recommended that you go to Alcoholics Anonymous, Mr. Martinez.
Correct.
You didn't take his advice.
He was preaching that to everybody. I think he's supposed to bring so many people in and blah blah blah.
Wasn't his testimony though that he doesn't do that?
I'm sorry. I've never heard that before. God. You know that I think that yoga is a pyramid scheme already, but I've never heard Alcoholics Anonymous being told that it's like a pyramid scheme where you gotta bring in so many new members. That's not how it works. Oftentimes people that are in AA get caught up in the life, and so they often talk to their friends and family and close people to them about it, but there's no quota. I promise you. That's hilarious. Oh my God.
That with all his friends? Just some?
Yeah, I guess it was.
Okay. You've testified that there's been no issues of domestic abuse between you and Heather,
Correct.
correct? Have there been any instances of domestic abuse while she was pregnant?
No.
Isn't it true that you left her in the UP when she was 8 months pregnant with Oakley?
I stated that I was going home, and I talked to her for 2 to 3 hours about it. And I didn't leave her. I begged her for 2 to 3 hours and told her I was going home. And she said that her sister was already on her way up there to pick her up.
Okay. But you left before her sister got there?
I did. She ordered me off her property. That is her property on the lakefront, and she ordered me off of her property.
Okay. So then you drove home.
She was sick of me begging her to get in the truck, and she forced me off there, and I went home.
All right. And that place doesn't have any electricity, does it?
I don't know what she's done to that. That's her property.
Okay. Is it true, sir, that on 11/21 of 2020, you yelled at Oakley for spilling your beer?
That's incorrect. I would never do that.
Is it true that you forced Heather to go to the bar on 4/25 of 22?
I don't force anybody to do anything, sir.
Is that a no?
Correct.
Is it true, sir, that that you claim in 2020-21 that you had a business made a net profit of $3,000.68? I might be wrong on that amount.
What's the business? I have 3 of them.
You have 3 businesses? I'm talking about your right now I'm talking about your tree service business. Does that sound like a roundabout figure?
It doesn't sound very correct. You talking with I guess you have to get more.
Which way you're?
You said,
I think I can look at the tax returns here.
was it 21 or 20?
Tell you in a second. This is 22 taxes, actually. $3,168 net profit or loss for Trigley E-Service. Is that correct?
For Higley's Tree Service?
Yes, sir.
Yeah, I was injured and I was working the time I wasn't injured. I worked at the restaurant.
All right. Prior years, you had similar type profits, though, correct?
Incorrect.
All right, let's take a look.
It's 2020.
How much did you make in 2021? What was your net profit for Higley's Tree Service?
Let's give us a sec here. Net profit. Looks like net profit is 10,125, but that's without my depreciation.
Okay. So going back to your 50-50 custody position, do you think when your businesses make that much that you can support her for that?
Well, that, sir, 21 was also when we bought, in July of 21 is when we bought the restaurant. And then I went up there and redid the whole kitchen, the whole laundry room, the whole back room. And I spent all my time up there at a restaurant working, not getting paid.
Just going to ask that your whole answer be stricken. And I'm going to ask it again. $3,168 or $10,000 that you just quoted for your 21 taxes. Is that enough to support Oakley for half the time for 50-50 custody?
Well, 50-50, I would also, you also have to put the depreciation in on there.
So I take that as a no, it's not?
Because I'm a business owner. There's a difference in the taxes of a business owner and
And motion, again, just ask the court. I'm going to object as being non-responsive.
Well, he's trying to explain it, and I think he's explaining it as a business owner, so I'm going to accept the answer.
Okay. Sir, you've testified that you don't have any after effects of the accident, correct? Of the motorcycle accident?
correct.
So how many days were you in the ICU? It was like 14, wasn't it?
Somewhere in that vicinity.
All right. And you're saying you weren't diagnosed with any brain injuries of any kind?
You can look at the doctor paperwork if you'd like to.
Just a concussion?
Just that blood on the brain that drained in like 3 days, and they were like, wow, that was awesome.
Have you done any cognitive or physical therapy since the accident?
They told me I didn't need to.
Okay. Didn't Heather come and stay with you in the ICU while you were at times while you were in the ICU?
At times.
All right. And her mother was watching the child, correct?
Correct. But I don't know. I was in the hospital, so if that's what you say, then that's what you say.
So you didn't ask her who was watching Oakley?
Well, I was out for 6 days, so it's kind of hard when you're knocked out.
So you were out for 6 days, but yet you didn't have any traumatic brain injury or after effect?
I just soon give you the paperwork from the doctor, sir.
Okay. Is that it? I'm just asking you, is that a no? You didn't?
That's your second time asking me. I said no the first time, sir.
When you were you involved in any other accidents besides the motorcycle accident?
Nope.
Were you involved in any accident at Higley's Tree Service?
I mean, I hit deer. If that you call that an accident, I've hit 5 or 6 deer in my lifetime, but nothing where I was injured.
Were you ever injured as a result of anything dealing with cutting down any trees?
I've cut my knee before. but nothing massive serious.
Okay. And then you've already talked about the accident with the red Wrangler where you hit a construction barrel, correct?
It's actually a F-250, if that's what you're saying I hit the barrel with.
Okay. Okay. To the best of your knowledge, does Heather have any problems with her physical health?
I don't know. She goes to the doctor all the time. I don't know why she won't inform me. So I guess I don't have the knowledge you're asking for right now, but we could look into her doctors if you'd like. I know
I'm just asking you if she has any physical problems, any physical health problems that you've observed as a layperson. Physical health problems.
Not that she's informed me.
Okay. Do you know a gentleman named Michael Plushnick?
I do.
In the last 2 years, how often have you talked to him?
I'm trying to think. We defriended each other when I stopped out to his house one time and he was with his girlfriend. And so the last 2 years, we haven't been friends.
Have you talked to him recently?
I did talk to him about a week ago.
Did you talk to him because you realized he'd been subpoenaed by us?
I called and asked him because I heard a rumor that I didn't know anything about being subpoenaed, but I heard that Heather went to his door and forced him to write some type of statement.
Okay. Did you tell him that you were going to win this case and Heather was going to lose her job?
I said nothing of that.
And is it true that you used to grow marijuana with him?
I never grew marijuana with him. I had those plants out there that one time when Heather was helping me with it.
Well, wasn't it 12 for you and 12 for him?
That's incorrect. He had his own fenced in, locked, and I had mine on my property. We never did anything together.
Okay. Did you? Heather doesn't smoke marijuana, does she? Is that fair to say?
Correct.
You testified that Oakley is going to preschool, right? Yes, sir.
The school that I agreed that she could attend 2.5 hours twice a week.
Okay. And she consulted you with that, correct?
Yes.
In the have you ever made any threats to Heather about threatening her with court action, like you're going to hear from my lawyer or something during this case?
Never. I said I have to speak with my lawyer to answer that question, but I've never threatened my lawyer.
You sure about that?
Yes.
Can you look at your text message from 2/5 of 23?
Just read it to me. I believe you.
Okay. You say, how's the restaurant? Do you want to sell? Hope you had a good weekend. Thanks for hanging up with my daughter. Devil. No communication for days. See you in court. With my daughter for days, excuse me. See you in court. You remember saying that?
I do.
And then she responded to you?
I mean, if that's what you have in front of you.
She says, listen, Dale, you can record anything you want about that conversation tonight, but let me tell you the truth. when you swear at your daughter because she's not giving you attention you think you deserve, I will hang up. She does not deserve your emotional roller coaster when you call back and she tells you that she doesn't like how you're talking to her or me and argue with her. That's emotional abuse. If you read these texts in the morning and don't remember any of this, I hope you remind yourself of why it's better not to call if you've been drinking. I'm going to turn off my phone now to spend time with our very upset daughter. Do you remember seeing that?
That's a false statement, but I do remember seeing that.
Okay. Sir, do you remember an incident where Oakley hurt her knee?
I do.
I just have a few more questions for you, but I wanted to ask you about this. Okay. And do you remember how there was a video made of her which you felt was kind of humorous?
Correct.
All right. And what was, well, I can't ask you what she was saying in the video, but did you and Heather get into an argument about this? Is that true?
We both felt it kind of humorous.
Isn't it true that in that video, Oakley didn't have any clothes on?
I don't know. I'd have to look at it again. It's been a long time.
All right.
I believe she always ran around in her diaper. I'm sure she had a diaper on.
Okay. But you just said you weren't sure.
I guess I'm not sure. It's been a long, almost probably 4 years ago.
All right. Did you send that video to Lucky, your friend?
I don't remember. I know I showed it to Grandma. I don't know if I sent it to Lucky.
Okay. Did you show that video? If I were to tell you that Lucky called my client to discuss that video, would that be inaccurate or would you just not know?
Well, I'm not sure how I would know if somebody calls somebody else.
All right. Let's assume, since you can't remember, that you did send this video to Lucky. After his testimony today, does that give you any concerns?
About we were laughing because she was funny when she hurt her knee.
Let's assume, for the purposes of my question, that Oakley didn't have any clothes on, and you sent this video and shared it with individuals. Does that give you any concern, considering Lucky's testimony today and what we found out about him?
I guess we just don't look at, infants the way each other does, I guess.
Are you concerned about your friend Lucky being investigated for something inappropriate with a child?
Not at all.
Are you aware that he testified to that today?
I am.
Okay, Your Honor, I believe that's all. Well, I'm sorry. Let me just check and make sure. I have a couple more questions. Something I wanted to clarify. You said that you saw her by a swing at her, where Heather is staying right now? That Oakley was swinging on a swing?
All by herself?
Right. You said that. Has Oakley been hurt over there in any way?
I don't know. On that swing, I don't live there.
Okay. But you haven't been privy to any information about her having to go to the hospital or being a victim of any crime or anything like that, correct?
I don't get any news.
Okay. Yeah, that's your position. There's no communication, but before you separated from Heather, did you go to church?
I did. That's who introduced her to the Crossroads.
You said you fixed up your mother's house, correct?
Correct.
All right. And you rewired and did electrical and drywall and all that. Are you licensed to do this work?
I think you got the knowledge that I'm a licensed lineman.
Are you licensed for electrical?
You can work on your own home that you own, that you live in.
Okay. I'm just asking you if you're licensed, sir.
I'm a licensed lineman.
All right. Your Honor, I don't have any other questions at this time.
Okay.
Thank you.
Ms. McNiff?
I do have some redirect. Mr. Higley, do you use your lineman training at all in your business?
I do.
And so since Oakley's been born, can you tell me all the different places where Ms. Borden has resided?
Oh, man. Yeah, she takes her to, well, it's not her grandma's anymore because she passed away, but it's her aunt's. She takes her to her cousin. She takes her.
Let's go with cities.
Oh, man, I'd have to look them all up. I can pop them out real quick.
In answer to a question by Mr. Zoglio, you had indicated that at one point Ms. Borden had moved to Jackson.
Yep, one's in Midland.
And I'm talking about places where she's lived, not where she's visited.
Okay.
Since Oakley was born, what cities has she lived in?
She lived in Jackson. She's lived in just north of Lansing, which is St. John's, I believe. Maybe Elma, Ithaca, right in there. She's bounced over to what's the name of that? Met her at this time. Let me zoom up right here. Leslie. She lived in Leslie. I think that's it.
Has she lived in Marshall?
Oh, and Marshall also.
And has she lived in Mason?
Mason.
Has she lived in Paradise?
Paradise.
Are those the main places where she's lived since Oakley was born?
Yep.
Now, after
I don't know if you left out Jackson.
Now, after Ms. Borden moved to, how long did Ms. Borden live in Jackson?
Just for the time I was in training for lineman, 4 months.
Did she buy a house or did she rent a house?
She rented an upstairs.
And then after you got done with your lineman training, she moved back to Marshall?
And when I flew back, she would move back into our house in Marshall. But then when I went back to New York for my training, she would go live in Jackson with her mom.
So were you broken up when she moved to Jackson, or were you still together?
We're still together.
So you didn't break up as a couple until June 2nd?
No, I offered her to stay at my place for free, but no cost, like she always has done.
Okay. So Mr. Zoglio had gone through a bunch of different places asking you if you go there. Can you, Mr. Zoglio isn't from here. Can you describe Grand River Brewery, what kind of an establishment it is?
Yeah, they focus on dinner. It's a higher class meal place where some pieces of meat are $60, $75. And Heather liked to go there because it was half off on Mondays and she didn't have to cook.
And Dark Horse Brewery, is there food at Dark Horse Brewery?
They're famous for their pizzas, and a lot of people like going there for their pizzas.
And do they have any other kinds of shops there?
Yeah, kinds of. Yeah, they have a bakery there also. I forgot about that. People come from miles around just to get stuff from that, like they do at our restaurant, bakery.
Have you ever gone there for the bakery?
I have.
And then there's the Copper. What kind of an establishment is that?
It's actually a place where they have probably 15, 18 TVs, so you can see all the sports, and it's mostly to go there to watch sports that you have to pay per view or something, or it's you pass or some special thing you got to pay for, so you go there and watch it for free.
Do they serve food?
They do serve food.
And do you go there to eat or to watch games or to drink? Or
I always eat when I go there because I love their burgers. So.
And Cascarelli's, what kind of place is that?
Cascarelli's is designed just for pizza. They're famous all over the state for their pizzas, and they're pretty expensive, but it's darn worth it.
Okay. And what's the Bogar?
Bogar is actually a theater. That's where I took Oakley for her first movie.
So it's a movie theater?
It's a movie theater.
And what is We Are Saints?
We Are Saints is more of a pool hall.
So when Mr. Zoglio was listing off the dates that you've been to these various establishments, do you know whether you're there to eat or to drink?
Like I said, from the not having anybody in my home anymore, it gets boring sitting there at night by myself, and I like to go spend times with friends I haven't seen in 6 years, because Heather would get upset if I spend any time with friends.
Okay. Now, Mr. Zoglio had asked you about an incident that occurred on September 3rd of 2022 when a Tim Esser gave you a ride home.
He sure did.
Can you tell me what that evening?
That evening, there was a band where Marshall City shuts down the main drag through town, and they have a few bands down there. And I knew that I would be drinking, so I parked at my mom's, which is 1.5 blocks from the downtown road. And so I had my drinks and danced and had fun at the band. And I went back to my house.
How did you get back to your mom's house?
I walked. It takes like 3 minutes to walk from downtown.
And where do you generally keep your keys to your car?
So owning a business and having 5 or 6 vehicles, I keep all of my keys in the ignition.
And you don't take them out and lock your car?
I don't.
And is that always true?
100% of the time.
When you're out of town or just when you're in town?
When I'm out of town, because my employees use my vehicles.
Okay. And so that evening on September 3rd, 2022, do you recall seeing Tim Esser?
I did.
And at what point did you see him? What were you doing?
So I was walking almost back to my mom's house, and we were talking in the road, and I opened the door to lean in to grab the keys out of the ignition to go in. As I was explaining he was like, man, if you need a ride home, blah, blah, blah. And I was like, well, I can sleep here. There's 2 beds and a pull-out couch here. I'm just going to go in here and do it. And he's like, well, I'm heading south right now. If you need a ride, I can take you home. And I said, well, if it's not out of your way, I'm not going to make you drive out of your way. But if it's on your way, I can jump in with you. So then instead of taking the keys and opening up the door to go in and sleep, I got a ride home from Tim.
I would ask the court to strike any testimony that he said that Tim Esser said, because that's hearsay.
Well, it wasn't to prove the truth of the matter.
I'm going to overrule the objection. It's not offered for the truth of the matter asserted.
So you touched on an incident with Mr. Zoglio about being in the Upper Peninsula when Ms. Borden was pregnant and you left. Can you first describe the property that you were on?
I can. We were up there all summer building a cabin because it's on the lakefront of Lake Superior. And this is Heather's property, and she paid for the cabin. And we got into an argument. And I said that I am leaving, going back to Marshall. If you would like a ride, get in. And she said, I'm going to stay in this cabin. My sister's on the way. And we fought for, or discussed it for a couple hours of, hey, I'm really leaving. I'm not kidding around. If you would like a ride, jump in. I can take you back. And she said, I just text my sister. She's 3/4 of the way here. I'll find my way home.
Did you have any concerns about Ms. Borden's safety at that point, given the fact that she was pregnant?
Well, I built the cabin, so there's a bed in there, and we do have power there because I still have my generator in that cabin to this day. My generator's there, and it just plugs into the generator because I can do wiring.
Did she have a telephone?
She did have a telephone.
And was it capable of being charged?
There was a generator right there running the building, and she could plug right in.
And did she know how to run the generator?
She's done it many times.
In 2022, how much time were you able to devote to your tree business as opposed to other years?
A very few amount because of the berry patch and my accident.
Okay.
So.
And what about in 2021?
2021 of July, I cut way back, and we were going up there for a week or maybe 2, or 3 weeks out of a month. We were up there redoing the new restaurant and everything, and I didn't work a lot because of that. I was putting my time into that.
So in the last couple of years, when Mr. Zoglio was focusing on your income, have you been able to pay your property tax bills?
I have. My mother's also.
Have you been able to pay your utility bills?
I'm not behind in any of my utilities, electric, nothing. Taxes.
Have you been able to pay your workers?
I've had solid workers, and yes, I have.
Have you been able to pay your vehicle insurance?
I sure have.
Purchase groceries?
I have been supplying food.
Is there anything that your daughter needs that you've been unable to afford to purchase for her?
Not one thing.
Mr. Zoglio had asked you about a Michael Plushnik. How do you know Michael Plushnik?
He's my neighbor.
And how long has he been your neighbor?
He's been there a good 8-10 years.
And you had a falling out?
We had a falling out because I walked over to his house when he was making out with his girlfriend, and he got mad that I broke it up when I didn't even know they were outside.
Okay. And does Michael Plushnik have any peculiarities that you're able to notice?
Yeah, he was in the Navy, and he got discharged because of a mental issue a long time ago, and the government supports him.
I would object on the grounds of lack of foundation.
I agree. My question was a little bit different than that.
Okay, sorry.
What asks what have you observed about Mr. Plushnik that maybe make him a little bit different than other people you run into? What have you observed? Not what he's told you, or what?
I've observed that he's slow mentally.
In what way? Like, can you give me an example?
It's hard for him to understand things, and for him to it's what I'm looking for. Pronounce, like if he's trying to tell you something, you might think he's talking about something different. He's hard to understand because of his handicap.
Okay. And can you tell me a little bit more about this text argument that you had with Ms. Borden, where you call her a devil and she accuses you of swearing at Oakley? What happened on the phone that evening?
Yeah. Sorry, I was trying to remember what we were talking about. Her and I were in a little argument on the phone. And then at the end of it, she said that she had it on speaker, which I know she didn't, because I would have heard my daughter in the background or whatever. But then she blamed me that I said it all in front of Oakley. And she said just as much as I did. It wasn't just a one way.
So were you swearing at each other?
Correct.
were your voices raised?
Correct.
Do you recall the video that you took that Mr. Zoglio was asking you about when Oakley hurt her knee?
I do remember when she hurt her knee, and I believe the whole thing was the reason I sent that to my friends is because she said I hurt my effing knee, and she was only like 2 years old. And I don't swear around her, and I know Heather doesn't swear around her, and the only other place she would be is at one of her grandma's. So I don't know where she got the word from, because we don't swear in front of her, but that's what was funny, because it just came out like it was like a normal word to her. And she's never swore since. That's what's funny about it. But
do you recall her being naked in the video?
I don't recall her being naked. No, I don't. I believe she always wore diapers running around the house. And she always took her clothes off. That was just the thing. It wasn't my doing. It wasn't Heather's doing. She was warm, running around the house in the summer.
At the time that you took the video, did you show it to Miss Borden?
I did.
And did she express any concerns about you sharing it with anyone else?
I think she was the one that was like, "Get a recording of that. That's hilarious." So then I took my phone and recorded it.
And have you ever allowed your friend Louis Lucky to be alone with your daughter?
Never once.
And
Nobody.
would you? Nobody meaning?
Nobody besides the only one I've left her alone with is her grandparents. Babysitting.
And why is that?
Because Heather and I were both working.
I mean, why would you not allow her to be with people other than her grandparents?
I just love her. I want her to be safe and keep her happy. And she's, again, not a public person. She doesn't know how to communicate with people unless they're, family.
I have no further questions.
Okay. Well, I see we're about 4:30. Mr. Zoglio, do you want to wait on your recross in this matter?
I'll be pretty brief in the recross, Your Honor.
Okay.
If it pleases the court.
Okay, I'll let you go ahead then.
Thank you. Sir, regarding the video, you seem to have more of a recollection of it when your counsel asked you. Are you aware that you didn't tell us that you did send it to all your friends, and you just testified that you sent it to all your friends?
So did she. Everybody sent it everywhere. It was hilarious.
Didn't she get mad at you for sending it to your friends? Didn't she get mad at you for that? Didn't you guys have an argument about that?
False statement.
So what you're saying is that it was okay for you to send, even if she was in her diaper, it was okay for you to send that to your friends from your perspective.
I don't see a reason wrong with that.
Okay. Now, regarding the incident where you called her a devil that your counsel just asked you about, you said you guys were swearing at each other, right?
It was normal. It happened a lot.
Okay. But in this particular incident, I'm not talking about whether it was normal or not. I'm talking about, you just said you guys were swearing at each other, correct?
You're correct.
All right. That's what your testimony is. So the proper thing for her to do, for Heather to do, would be hang up the phone. And that's exactly what she did. Is that right?
It's incorrect. We argued on the phone.
So do you think that swearing in front of Oakley is appropriate and she should have not hung up on you?
I assumed Oakley wasn't in the vicinity the way she was speaking. I don't know where Oakley was. I wasn't in the vicinity where Oakley was. Heather was.
If you two are swearing at each other, is it a good idea to hang up?
I guess everyone has their own opinion.
Okay. Sir, you testified earlier that after your accident, you don't drink very much because it gives you a headache. You remember that?
Number 3, that's correct.
And your accident was on September or I'm sorry, June 2nd, 2022.
Again, that's correct.
But you've testified multiple times today that you were intoxicated on September 3rd. So your headache, you didn't have a headache, or that didn't bother you then.
Well,
Right?
the first time that it happened, I didn't think, oh, that's my accident. So I did it a few more times, and then I finally realized, oh wait, this drinking is causing the headache. It took me a couple times to learn, a week or two or whatever. I don't know the exact dates, but it took me a little bit to finally go, wait, maybe it's alcohol. And then I stopped drinking and stopped headaches. So then I just assumed that was the issue.
It's interesting that you did not. Is it true that you did not testify that on September 3rd during this whole Tim Esser episode that you had a headache? You never said that today.
Well, you never asked, sir.
Okay. The council asked you about all these places, and your council's correct. I'm not from Calhoun County or don't live there. But she asked you about all these places: We Are Saints, Coscarelli's, Copper Pub, Grand River Brewery, and you gave an explanation for them. But all those places serve alcohol. Is that right?
It's actually Copper Athletic Club.
Okay, but they serve alcohol too, right?
Yeah.
All right. And in fact, you used to get your keg refills at the Grand River Brewery. Is that right?
I did.
Your Honor, I don't think I have anything else.
Okay, thank you. Why don't we conclude now? I don't know about starting any other witnesses at this point. So why don't we conclude? It's now 4:34 p.m. and then we'll resume on.
We'll resume right now with the magic of YouTube editing live for your pleasure. Please take this opportunity to go and hit that like and subscribe button while I prep the next hearing, folks. Please, we're not going anywhere. It's going to be in this live. It's coming right up. All I need for you to do is make sure that your attendance has been taken. And you do that by hitting the like or the dislike button. Either or is fine. Also, if you're new here, feel free to ask questions. We are fun people. We watch lots of court. And this hearing has been going on and on and on. It's finally time to hear from the other side. I am ready to hear from the other side. I am not expecting much, to be frank with you. The lawyering has sucked in this case. The chat is better lawyers, to be honest. Anyways. But we are back on another day. We still have, angles are important, people. Angles. Angles, angles, angles. Anyways, let us get into the rest of this case. And
The continuation of the trial
oh,
commenced
yeah,
on.
Judge, I'm not. Hold your freaking horses, Judge. Here we go, guys.
April 11, continued on April 14th, and then on today's date, the court notes.
Whoa, hold on. Continued on April 14th. Shit, did we miss one? Oh, we gotta check. I gotta check. Hold on. Rechecking. April 14th. Because the last one was April 11th. Ugh. Okay, hold on. Because I can't give you guys the wrong stuff. We gotta get all the hearings if we can get them. So please continue to hold. Talk amongst you. Monica, thank you so much. You're so nice. That is so kind of you. Thank you. You rock so much. You guys are all amazing. Biggins link? Yeah, sure. You can put whoever. We always support all our creators in this room. Sorry, I'm just actively trying to not miss this hearing, but I swear to God. He said April 14th, right? I don't know what day that was. No, that was April 4th. Okay. Sorry, guys. We are doing this live, as you can tell. And he doesn't rename his streams anything. He just like sort of calls them all the exact same thing. Oh, wait, was that it? No. April 10th. Oh, you know what? We're going to feel really dumb because I think the one that we're looking at is April 14th. But let's just make sure. April 14th. No, it's not. Okay. Okay, give me 1 second. God damn it. They don't date them. Dang it, Bobby. Why is it so hard for me to find? Um, I'll show you guys what I'm looking at because maybe you can tell me which one you think it is. So these are the ones we just finished. We just finished this 3-hour one, so it's subsequent to that. It's none of these people thus far. I don't think it's them. I don't think it's them. No. 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 And then here they are again. Oh, continued. Did he say continued on April 14th as in like they continued it? Let's just listen again to what he says. This might be what we're watching.
Notes that when we ended next week, but again, unfortunately, it caused us to delay a little bit. Court will note that this matter is a continuation of the trial commenced on April 11, continued on April 14th, and then on today's date, the court notes that when we ended, Ms. McNiff, you were at that point going to commence any recross of the defendant. Ms. Borden, recognize you're still under oath, okay?
I actually have no further cross.
Oh no, then we totally missed her frickin' testimony. We have to find it. Okay. I have to look for it, guys. I'm sorry. That's completely so the 14th? Damn it. I'm sorry that I'm not on top of this better, guys. I really thought I had the right hearing there, but I do not. Where is it? I don't. I really don't see it anywhere. I swear to God. You can hear Nana listening to the like, stuff about the coronation, I think. Anyways, that is very strange. Okay, so 11th, and then let's just look. Next day was the 12th. Okay.
Time slot, what's the,
I'm so
Seriously, guys, I am not kidding you. I can find only like a 12-minute or a 13-minute video before the next one. Damn, I wonder if all the good juicy stuff was taken down for some reason. That's really shitty.
we have the defendant present?
yes, that's Gabrielle.
Hmm. So let's take a vote. Do we want me to figure this out and look for more or continue with what we've got so far? Yeah. Seriously, there was nothing on the 14th. Very odd indeed. Okay, I'm sorry, I'm just gonna look at the chat now. I've just been like looking all over for this thing. Um, I just don't know where it went. I don't think there's any more other than what we've got. Let's see what happens and maybe hold on. Let's see. Because they said she's still under oath. 27 minutes. Yeah, just continue. I know. I will. I get stuck on things. If I start, that was the 19th. I swear. Oh, yeah. It is driving me crazy. You don't even know. Especially because they're not, and this is why I understand now, like, why you want YouTube titles to be different because he's named them all the
Time
exact
slot,
same
what's
thing.
the,
There's
I'm
just
so
no difference to them. Anyways, okay. Here's what we're gonna do. I am going to continue watching it with you guys while I also look further and see if I can't find the other part. I guess that's the way we do. Just give me 1 second. And I'm dragging things out of the way. Cannot escape Alt F4. Cha, you have 5 videos saved to this case. We just finished the first 3 videos and there's 5 videos. But the sounds like there's a middle video in there from the 14th of April that we don't see. Because what he's referencing is her being on the stand and under oath already. And we just played the first 3 videos, one of which was like 2 hours, one of which was an hour, and one of which was 3 hours. And then the next video that was up was from the 21st of April. And that is the one where he's just introed it and said, you're already under oath and you're on recross. So, maybe I should just play it and stop worrying about it. Oh yeah, I'm good. I am Gouda. Yeah, I got 5 videos too, so I guess that's what we got. Let me.
Cross of Ms. Borden.
Okay, so you have none, okay?
Correct. So we would be moving to rebuttal at this point.
Well, Mr. Zoglio, does he have any other witnesses at this point?
Your Honor, no, I didn't have any other witnesses. And last we left off, my understanding is counsel did request rebuttal, and I did want to inquire of the court about the rebuttal situation.
One last thing before we go forward with this. There's one other video. It's this one. Let's just see if maybe they just put them in the wrong order. No, it's from the 21st as well. I'm just trying to see.
Yeah, must have talked to everybody that knows you, huh?
I think that's got to be it.
Yeah, that's good. Well, and we mentioned it too, didn't we, during on the record about
Yeah.
how you were concerned?
We did, and I think maybe that helped.
Good.
Okay, good.
Yeah, it might have been.
Oh.
Yeah, it might have been.
Hopefully it did.
Hold on, I'm almost there.
Yeah, hopefully you get relief from that, because nobody wants that hanging
No.
over their heads.
Absolutely.
Okay, we are back on the records.
Okay, Mr. Zoglio, any rebuttal?
A brief rebuttal, Your Honor. I'd call my client.
Okay. It's not this video. This is so annoying, you guys. I know you're all with me and I'm looking for April 14th. You have it? I have the April 21st one. It's the April 14th one that he references in the April 21st video that I don't have. Let's just listen again and maybe, no, we can't be missing it. Like, she didn't testify yet. We want to hear her.
A rearage in this particular matter. What the court's going to do is I am going to redo.
Now we move on to. Good morning. Thank you for your patience.
Morning.
Okay, we're already on the record, so I'll just call. This is 2022-2420 DC, Dale Higley versus Heather Borden. It is Friday, April 21st, 2023 at 8:36 a.m. Attorney Lisa McNiff represents plaintiff and attorney David Zoglio, defendant.
Good morning to all of you. Court will say sorry for the delay in this matter. I guess I'd say unfortunately, we ended up putting settlement on the record before this, and then we also had front of the court bond review hearings. So we didn't expect the other matter to go ahead today, and well, thankfully it did. We were able to get resolved a trial for next week, but again, unfortunately, it caused us to delay a little bit. Court will note that this matter is a continuation of the trial commenced on April 11, continued on April 14th, and then on today's date, the court notes that when we ended, Ms. McNiff, you were at that point, going to commence any recross of the defendant. Ms. Borden, recognize you're still under oath, okay?
I actually have no further cross of Ms. Borden.
Okay, so you have none, okay?
Correct.
So mad.
So we would be moving to rebuttal at this point.
Well, Mr. Zoglio, you might have, does he have any other witnesses at this point?
Your Honor, no, I didn't have any other witnesses. And last we left off, my understanding is counsel did request rebuttal. And I did want to inquire of the court about the rebuttal situation. But I agree with Ms. McNiff. We were done with our case in chiefs, and I believe that Ms. McNiff said she had rebuttal. But if the court could hear whenever the court wants to hear my inquiry, I can give it.
Okay, well, go ahead, I think Ms. McNiff's ready to proceed with rebuttal, so you can go ahead and address her rebuttal.
Thank you, Your Honor. Your Honor, my understanding is rebuttal is, I guess we would ask for a specific offer of proof to rebuttal. Both people have had ample amount of time to testify, and unless there's a rebuttal to a specific instance of conduct or specific event, we will be objecting to any new testimony with any new witnesses that are brought with new issues. And I assume that's the court's philosophy on that or position. I don't know.
Okay, well, let me, I guess, highlight that for you. Obviously, it's rebuttal, so you have to be rebutting something. That we're not going to have rebuttal for purposes of opening up other or additional avenues of examination. So I assume, Ms. McNiff, you're offering it as you propose for rebuttal purposes of other testimony. Is that correct?
Correct, Your Honor.
Okay. With that, I think it obviously falls within the parameters of rebuttal. And I guess, Mr. Zoglio, if she goes beyond that particular scope, you obviously have a right to object. And if she goes beyond that particular, I guess you say parameters, the court's not going to allow her to if you object. So, Ms. McNiff, you can proceed with your rebuttal. And who are you calling?
Are there people in the waiting room?
Yes, we have two. I have a Michael McIlvain.
Correct. And Matt Sill?
I believe so, yes.
Could we call Matt Sill, please?
Yes. And that was spelled S-I-L-L.
Yes. We had it before.
Okay.
Mr. Sill, you had previously testified, and we're having you come in for a rebuttal at this point. What I'm going to do is have you sworn in again, then we'll proceed. So if you would raise your right hand, sir.
Yeah, okay, there we go. He's unmuted. Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Go ahead, Ms. McNiff.
Thank you, Your Honor. Mr. Sill, have you been on a golf league with Dale Higley?
I have.
And what year?
Last year?
So 2022?
Yep.
And do you recall approximately how many weeks he played in your golf league with you?
It's approximately 20.
And was he there for every golf league night?
No.
And do you have any idea out of those 20 weeks how many he missed approximately?
Well, there was the accident. So he missed probably, I don't know, 10, maybe 10 weeks there. Other than that, a couple here and there, not too many, I'd say.
Going to object on the grounds of speculation, Your Honor. He obviously doesn't know the answer to the question.
Well, I'll take it. I mean, I recognize he says he doesn't know, but he believes that there were some other dates. We'll just accept it for that, and give it the appropriate weight.
Okay.
Did you and Mr. Higley drink alcohol when you were playing golf?
Usually, yes.
And did Mr. Higley become intoxicated every time when you were playing golf?
No, we would have 6 beers, 3 each for the round. Generally, it was not totally unusual to have a last round on the 18th.
Hold on, I may have actually found the 14th. You might be shocked why I couldn't find it, or I didn't identify it to begin with as the hearing that we were missing, because it's 3 minutes long. But I do believe that we have that. So if you'll just stand by for one moment, please, folks, I will play you that other part, and then um we will continue on with whatever this is. But I certainly thought I was looking for something longer than a 3-minute video, so that is why I did not think that video was the one. Okay, here we go.
Oh, there we go. Oh, no.
Here we go.
Okay, can everybody hear me?
Yes.
All right. Well, good morning to everybody. We just had a thing here, so I already called into session. So this is case 2022-2420 DC, Dale Higley versus Heather Borton. It is Friday, April 14th, 2023 at 8:34 a.m. Attorney Lisa McNiff represents plaintiff and attorney David Zoglio defendant.
Good morning to everyone.
Morning, Your Honor.
This is a continuation of the trial commenced on April 11, 2023, when we adjourned last. The proofs were with you, Ms. McNiff. Do you have any additional witnesses?
I do not. I do have a couple of preliminary matters, though, Your Honor.
Okay, so you have no witnesses. Okay, go ahead.
Your Honor, first of all, when we agreed to have this trial today, I had neglected to remember that I have a 5 o'clock appointment, and also Mr. Higley has a 5 o'clock appointment to see a customer about cutting down a tree. So
Well,
there's a possibility we could end at 4:30.
well, that's good, because I have an appointment at 5 o'clock as well. So we're all on the same page today.
Awesome. The second,
Well, we'll end sometime whenever we can take a break, maybe anytime between 4 and 4:30, when, maybe depending upon the witness, when it's a natural time to break.
thank you, Your Honor. The other thing is a little odd. So since we had that 8-day trial back in November, December, I have a stalker who's been texting my office with screenshots of me in trial, only with you, Your Honor, for whatever reason. I think the stalker likes me, maybe a little too much, and it had stopped for a while until this last week when we had this trial on Tuesday, and now I'm getting more screenshots, and I'm sure Your Honor will find this amusing. My stalker thinks I'm an angel. And
Well, tell him to call me and I'll set him straight.
I could do that. I have talked to Ms. Getting about this, and I've also made a police report because it's getting a little much. There's a
Okay.
phone number connected. I'm wondering if there's any chance we could not stream on YouTube. Or can you direct the stalker to leave me alone in case he's on?
Well, obviously, no one's.
Yes, I'm happy to do that for you, Miss McNiff. Hey, stalker, loser, freak, person with no time or no life. Leave the poor woman alone. She's just doing her job, and you have just ruined this for the rest of us. Now we don't get to hear this woman testify because of you and you stalking fucking Lisa McNiff. What the hell is wrong with you? Do you know how upset I am that I don't get to see another 8 hours of this testimony and I only get to see the next 4 hours? I'm serious though, guys. Don't ever dox anybody from any video that you ever see. of mine. And that's all we got for the 14th. So unfortunately, that's all we got. We have to go to the 21st. They did do it. Stalker of Lisa ruined it for everybody. So, too bad they couldn't just send Matt. God, what is his name? Now I forget. I want to call him Matt Spliff, but I know that's not his name. Matt. Matt Sill. Matt Sill. That's his name. Okay. Anyways, so I just let's just finish
Should be
this.
stalking you, etc.
I can open the door and stop the stream.
Yeah. Why don't we do that? I'll do that. I'll open up the courtroom and then we'll be able to take it off streaming.
We
All
can come in if you just open it. That's me having a bit of a temper tantrum about that. Anyways, we are now on April 21st. Apparently, stalker's no longer an issue. And I guess she got a haircut as well. So, let us watch the rest.
Okay. A last round of beer, you mean?
A beer, yeah.
Okay. And was Mr. Higley on a pool league with you after Oakley was born?
No,
And in 2022, do you remember him coming to watch you play pool?
he has a couple of times, yes.
And was it every week, or was it just like you said, a couple times?
A couple of times, once in a while.
And is it true that he regularly would get intoxicated when he would watch you play pool and then leave?
I've seen him have some drinks at the bar. I can't speak to his level of intoxication.
And is it true that there have been changes in Mr. Higley's personality since his motorcycle accident?
There have.
And have you seen anything? Have you seen him become more angry?
Not angry, no.
Have you seen him become abusive to people since his accident?
I have not.
I have no further questions.
Okay, Mr. Zoglio, any recross, I guess?
Just briefly, Your Honor. Mr. Sill, you just testified, maybe I misheard you, but you just testified that since Oakley was born, Mr. Higley was not in a golf league with you. Is that right?
I think the question was pool league.
Or I'm sorry, pool league. Is that true?
That's correct.
Okay, but he was in a golf league with you.
That is also correct.
And you said that during the is the golf league 18 holes or 9?
18.
All right. And during the 18 holes, you said that you guys would average about 3 beers each during the golf, right?
That's correct.
All right. And then you said on the last round would come around close to the last hole. So does that mean 4 drinks sometimes?
No, just 1 each.
Oh, okay. Well, and at the end, so that would be 4 total.
That would be 4 total for a 4-hour round.
Okay. And so you're playing golf and you're not doing anything else except playing golf and drinking. Is that correct?
Yes.
And you said something about having drinks at the bar before. Having drinks at the bar before what? Before golf leagues or pool leagues?
I don't recall what you're talking about. Drinks at the bar before.
Okay.
I was asked about if he would come down and visit me at pool league. I've seen him at my pool leagues on occasion, have a couple of beers.
Okay. And so even though he wasn't in a pool league since Oakley was born, he would still come down to see you and have a few beers while you were playing pool. Is that right?
Right, but he doesn't generally like the bars over here, so
Okay.
it's not an every week thing. It was once in a while.
Okay, and where was Oakley and Heather during that time that he would come down and have beers at the bar during your pool league?
I don't know.
They weren't there, correct?
No, generally no.
Okay. Council asked you about changes in Mr. Higley's personality. You said that you said he didn't have any anger issues since the accident?
Not that I've seen, no.
Okay. But isn't it true, sir, that you weren't living with him on a regular basis? So you know, your only experience is limited, to be fair.
That's true, yes.
Okay. All right, I have nothing else, Your Honor.
Ms. McNiff, any additional, I guess, redirect?
No, Your Honor.
Okay. Mr. Sill, thank you for your testimony. You're excused. You have a good day.
Thank you, Your Honor.
I would call Michael McIlvaine next.
Okay.
Just a moment.
And I may have to lay a few foundational, ask a few foundational questions just because I haven't had Mr. McIlvaine as a witness previously.
Could you tell me? Oh, there it is. We have to get him to unmute and appear there.
Oh, and he's sideways.
Yeah.
Please unmute, sir.
Could you remove your hat, please?
You're muted, sir. You have to unmute.
There we go.
There
it is. Is that better?
Yeah, that's good. Mr.
All right.
McIlvaine, we're going to have you render some testimony, but you have to be sworn in first. So if you would raise your right hand, we'll have you sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Ms. McNiff.
Thank you. And you can put your hand down. Mr. McIlvaine, do you spell your last name McElvain?
Yes, ma'am.
And do you know Dale Higley?
Yes, I do.
And do you know Heather Borden?
Yes, I do.
And how much time did you spend with Dale, Heather, and Oakley before you had a motorcycle accident with Mr. Higley?
Quite a lot of time, actually. I worked with Dale through the tree service a lot, and I also worked up north with him. We renovated a lot of the restaurant up north. So I spent quite a bit of time around all three of them.
Would you spend overnights in Paradise at the restaurant?
Yes, I'd spend overnights at a house that was owned by the restaurant and by, Mr. Higley and Miss Heather Borden.
Your Honor, I'm going to object at this time. I don't understand. I understand she wants to get some background information, but how is this rebuttal evidence to what?
Well,
We'll
see. I think it is appropriate to give some background so we know familiarity, et cetera, to at least lay a foundation. So I'll overrule the objection.
Thank you, Your Honor. Mr. McIlvaine, when you would stay at Paradise, would you see Ms. Borden's mother, Terry Borden?
Yes.
Would you see Oakley?
Yes.
Did you ever see, while you were in Paradise, Oakley run to her dad crying?
On a few occasions, yes.
And what did you see him do?
He'd pick her up and he'd hold her and say, "What's wrong, bud? What's wrong? Okey Pachoki," or something like that. And he'd figure out what was going on and he'd try to take care of the situation.
And where was Ms. Borden, Miss Heather Borden, when this was going on?
Heather would either be cooking in the kitchen or taking care of tables, or sometimes she'd be on a meeting.
And where was Miss Terry Borden?
A lot of times she'd be in the house, or she'd be helping in the kitchen bake or something of that nature.
Your Honor, can I get a time frame? I mean, he's just
Okay,
testifying to general things right now. I can't
okay,
figure out when this was.
okay. Try to qualify it with a time frame, Ms. McNiff.
Mr. McElvain, when did you see Oakley running to Mr. Higley crying up at Paradise?
Up at Paradise, I'd say most of the time when that would happen, it'd be when she'd be tired, about midday, noonish, and roughly time period of when, I'd say December. Trying to find a good remember. I'm sorry, I'm pretty foggy. It's been a while. I wish I had a calendar in front of me.
So last year was 2022. Were you there
Yep.
in 2022?
Yes,
Were you there in 2021?
a few times.
Okay. Were you there more in 2022 or 2021?
More in 2021, I believe.
Okay. And so do you have any recollection of whether or not the times you would see Oakley come crying to her dad were in 2021 or 2022?
I would say more. I was more around, more prevalent, and more 2021 than 2022, if I remember correctly.
Does that help? Does that help, Mr. Zoglio? Okay. Mr. McElvain,
I'm sorry, I can't. I just don't know. I can't really answer that. Thank you, counsel.
Mr. McElvain, have you ever seen Mr. Higley yell at Oakley?
If she had done something wrong, yes.
And have you ever seen him swear at Oakley?
No.
Have you ever seen him physically discipline Oakley?
An objection, lack of calls for speculation and lack of foundation. The testimony, I think, where the yelling and the disciplining and the spanking, that all came with specific dates from my client, and I don't see what he's rebutting right now.
We're rebutting the idea that the allegations that my client has put his hands on Oakley and has verbally abused her and emotionally abused her. Ms. Gordon testified extensively that he did that.
But in her testimony, Your Honor, no one else was around except for Mr. Borden and Mr. Higley.
Well,
So this witness wouldn't know that.
Ms. McNiff?
Your Honor, while we're not rebutting with this witness the exact incidents, we are rebutting the allegations that my client has been physically and verbally abusive to the party's child. I don't have a ton of questions. I can make this pretty quick.
Okay, well, I'll allow some leeway, but recognize that it is rebuttal.
I understand. Thank you, Your Honor. Mr. McElvain, have you ever seen, have you ever observed Mr. Higley verbally abuse Ms. Borden, Ms. Heather Borden?
No, not right offhand.
Have you ever observed him emotionally abusing Ms. Heather Borden?
No, not right offhand.
Have you ever observed Mr. Higley when he was taking care of Oakley?
Yes.
And have you observed him taking care of Oakley without Ms. Borden around?
Yes.
Have you ever observed Oakley with Mr. Higley when he was too intoxicated to care for her?
No.
I have no further questions.
Okay, Mr. Zoglio, any cross?
Mr. McElvain, how are you today?
I'm doing fairly well, thank you.
Good, sir. So, Mr. McElvain, you said you spent some time with the couple, but isn't it true that you didn't live with them, right?
No, I did not.
And are you a friend of Mr. Higley's?
Yes.
And I mean, and is it true, sir, that you've smoked marijuana and drank with Mr. Higley?
Your Honor, I believe that exceeds the scope.
Mr. Zoglio?
Okay, I mean, this is cross-examination, but I'll move on, Your Honor.
Okay, thank you.
I'll withdraw the question.
Okay.
Sir, do you remember a date of 4/2 of 2022?
4/2/2022. Vaguely. Can I get some basis behind that statement?
Sure. I'll give you more background on this. You testified on direct that you said you never saw Dale yell or be verbally abusive towards his daughter, correct?
Yes.
But on 4/2/2022, didn't you actually weren't you actually a witness when Dale yelled at his daughter about a scooter, about not riding a scooter?
I don't remember that, sir.
You don't remember that at all?
No, sir.
Okay. Let me ask you a couple more things about that. Do you remember drinking or smoking marijuana that day?
I might have had a beer. I don't remember. It's been a while.
Counsel asked you if Mr. Higley was too intoxicated to take care of his daughter, but isn't it true, sir, that that you went to the brewery that day and that you and Dale were intoxicated by noon?
At noon? No.
Yeah.
We were at Grand River at noon. We only typically go from 3 to 5.
Okay. And how often do you go from 3 to 5?
Occasionally, I'd say maybe once, twice a month.
Do you still do that?
I don't. That's just because of money reasons, but.
All right. And did you work for Mr. Higley in his tree business? Is that?
Yes.
All right. So I know I asked you this, but you haven't lived with the couple, so you don't know sort of what goes beyond closed doors. Is that a fair statement to make?
It is a fair statement to make, sir.
Do you have Got one moment, Your Honor. Counsel asked you a question about a time you were up in Paradise and the child ran crying to her dad. Remember that?
Yes.
Okay. There were other individuals there around there, correct?
Yes.
The child wasn't by herself?
No.
Okay. All right. I have no further questions.
Okay. Mr. McIlvaine, I did have just a clarification, is I think when Ms. McNiff was asking you about times that the defendant, or strike that the plaintiff, Mr. Higley, might have yelled at his daughter, you said if Oakley had done something wrong, the defendant has yelled, correct? Or did I get that? Is that yes?
Yes.
Oh, okay. I just when Mr. Zoglio, when Mr. Zoglio asked you, then I thought you contradict yourself. I want to make sure I had it correct. That's all. Ms. McNiff, any additional redirect?
No, Your Honor.
Okay, Mr. McIlvaine, that will conclude your testimony. Then, well, I should give Mr. Zoglio, because I asked a question. Do you have anything in reference to what I had asked?
No, thank you, Your Honor.
Okay. Mr. McIlvaine, now conclude your testimony. You're excused. Have a good day, sir.
You too. Thank you.
Okay, thank you.
Bye.
Any additional rebuttal, Ms. McNiff?
Mr. Higley, please.
Okay. Mr. Higley, what you're doing, you're still under oath. So with that, you can proceed, Ms. McNiff.
Mr. Higley, is the allegation that you kicked Terry Borden out of your house 4 days after Oakley's birth true?
Objection, leading question.
Well, I'm trying to establish, I don't believe it is leading, actually, Your Honor. I'm asking whether it's true or not. It's the allegation that's been made.
I'm going to overrule the objection. You don't suggest the answers, just asking if what the answer is.
I can answer that then.
Correct.
That's incorrect.
And did you insist on taking Heather Borden to the brewery a few days after she gave birth?
Incorrect.
Is it true that Terry Borden hasn't fallen in years?
That's false.
Have you ever personally observed her fall?
I've also assisted her.
You got to answer.
Objection, non-responsive to the answer.
I have seen her fall.
And do you have any idea of what year was the last time you saw her fall?
I've seen her every 6 years that I've known them.
Objection, non-responsive to the answer.
Asked him how often. He said every 6 years. Let me have him clarify.
Yeah, clarify, please.
When you say every 6 years, do you mean like she goes 6 years and then falls, or do you mean something else?
I mean that I've seen her fall every year for 6 years.
Is it true that when you and Heather were residing together, you were only home a few nights per week?
That's incorrect.
And do you know how many nights per week Heather was home?
I would say 5 out of 7.
And when you and Heather lived together, is it true that you'd never put Oakley to bed?
That's incorrect.
Is it true that you never helped her brush her teeth?
Incorrect.
Objection, that's not rebuttal evidence. Now, counsel, now it appears that counsel's questions are trying to rehab testimony on the custody factors. He never testified to this before, and Heather Borden also never testified that he never put the child to bed. We're going beyond rebuttal.
That's not correct. Ms. Borden did testify about all of these issues.
Never said the word never, Your Honor. Never brushed teeth. Never said that.
I can remove the word. I can remove
now we're
the word
trying
never.
to get into more stuff.
I can remove the word never from my questions.
Okay, go ahead.
Okay. Is it true that you didn't put Oakley to bed?
Incorrect.
Is it true that you didn't help her brush her teeth?
Incorrect.
Is it true that you didn't bathe her?
Incorrect.
Is it true that you didn't read to her?
Incorrect.
Is it true that you didn't buy Oakley clothing when you were residing with Heather Borden?
Incorrect.
Is it true that Oakley does not look to you for comfort?
Incorrect. Excuse me.
Is it true that Oakley always went to mom when you were together if Oakley needed something?
It's incorrect.
Is it true that you yelled at Heather to take Oakley out of the bedroom when she was little and crying?
False.
Is it true that you haven't purchased books for Oakley?
False.
Is it true that you don't teach Oakley about how to deal with her emotions?
Very false.
Is it true that you don't know how to install a car seat?
Very false.
Is it true that Oakley pushed over a car seat after you installed it?
False.
Have you ever told Heather that you would take Oakley for parenting time and then you did not take her for the parenting time?
It's incorrect.
Is it true that when you visited your uncle in 2020 for Thanksgiving, that everyone was hanging out in his garage smoking cigarettes and marijuana?
Your Honor, all this is just a straight denial of the questions, and their questions are compound questions, and they're just basically refuting compound questions that are leading and refuting what my client said. With
Mr.
one word.
Soglio, what do you believe that rebuttal is for? If it's not for refuting other testimony, I guess I'm at a loss.
Well, I understand that, Your Honor, but what's going on is the events that my client testified to. Mr. Higley is just simply saying incorrect, false, and they're questions with multiple facts in them and not even broken up. So I understand. I'm just.
Well, when you cross, you can go into that if you wish to do so. Go ahead, Ms. McNibb.
I was concerned that if I try to elicit a more detailed response, that I would get an objection that we were going beyond the scope of rebuttal.
Okay, go ahead.
Is it accurate that on Thanksgiving of 2020, Heather took Oakley for a walk.
That's incorrect also.
Is it true that you insisted that Oakley say hi to your uncle in a smoke-filled garage?
It's incorrect.
Is it true that when you resided with Ms. Borden that you would often stay out with your friend Matt until 3 a.m. or later?
That's very incorrect. It's impossible, actually.
Why is it impossible?
The only bar that I go to is obviously the Grand River, and that closes at 9 since COVID.
And is it true that when you lived with Ms. Borden that you would often come home intoxicated after golf league?
It's false.
Is it true that you would often come home intoxicated from Grand River Brewery?
False.
Is it true that you went to Grand River Brewery on a regular basis in 2022?
False.
Do you have any idea of how often you went?
I have a very good idea. If I can say it, I'm not sure if I can.
You can say it.
We went every Monday, probably 3 weeks out of the month. And then I like to go on wings night on Wednesday. And it was always from 3 to 5 because that's when the sales were.
Okay. Is it true that Oakley has to work hard to please you?
Not at all.
Is it true that Oakley has apologized to you after you've yelled at her?
I guess I would object on the grounds of hearsay.
I'm not asking for what she said. There was testimony that from Ms. Borden that Oakley regularly apologizes to Dad after he yells at her.
I'll overrule the objection. Go ahead.
Is it true that Oakley has apologized to you after you've yelled at her?
There's never been a need for her to apologize.
Has she ever apologized to you after you've been upset with her?
She has.
Is it true that when Oakley was a newborn that she was crying and you yelled at Ms. Borden to take her out of the bedroom?
That's very false.
And do you recall that incident that Ms. Borden testified about when Oakley was a newborn and she was crying?
I sure do.
And do you remember yelling to take her out of the room?
No, I do not.
Do you remember what happened?
I do.
What happened?
She hasn't developed this flap that lets air out. We found out this after a few occasions have happened. And the first couple occasions, Mrs. Borden and I did have an argument of whether to take her to the hospital because I was worried about our daughter. And so finally we ended up taking her to not the hospital, but to our doctor that I attended, and learned that this flap here that lets gas out doesn't develop, and she keeps acid in her stomach, and that's why she's crying, at nighttime because of the acid. And then the doctor said within so many months it would develop and everything would be fine, and it was.
Did you and Ms. Borden argue during that time when Oakley was crying when she was a newborn?
Yes, we did.
And were you angry with Oakley because she was crying?
No, we weren't even in the room when we were in the argument, Heather, Ms. Borden, and I.
Your Honor, can I get a date on this so to see if this is rebuttal? Sorry.
What I recall was that Ms. Borden testified that this was maybe 3 or 4 weeks after the child was born.
Thank you.
Mr. Higley, is it true that on Saturday, November 21st of 2020, that Oakley knocked over a beer at your house?
That's incorrect.
Is it true that on that same date that you tossed her on the couch?
Never.
Pinned her down?
Never.
On that same date, did you push Heather?
I have not.
Did you yell in Oakley's face?
Never.
Did you throw a telephone on that date?
No.
Is it true that on Tuesday, August 23rd of 2022, that Oakley was making a noise on a cabinet door?
That's false.
Is it false that she was making a noise, or what's false about the statement?
I don't remember her playing with a cabinet door, much less making noise with a cabinet door. She's a good child.
Okay. Was there ever a time that you can recall that she was making a noise and you got angry with her?
The slamming door incident, why I was in bed.
Okay, and do you recall if that was on Tuesday, August 23rd of 22?
I'd have to look at my notes.
Yeah. Look at them and refresh your recollection and put them down and let us know.
Said August 22,
Yeah, August 23 of 22.
23 or 22. Okay,
Do you, now that did you refresh your
I
recollection?
have now.
Okay, do you recall that date?
I do.
And was that a date that Oakley was making a noise?
She was slamming the bedroom door against the wall
Okay.
while I was sleeping.
And is it true that you jumped out of bed?
I don't know if I'd call it jumped, but I did get out of bed.
And did you snatch her up?
I did not.
And what did you do?
Oakley sat down while I was getting out of bed. She sat down where I could not shut the door because that was my intention of just getting up and shutting the door. She sat down where I was unable to shut the door. So I picked her up and I walked her to the living room and I sat her down. As I sat her down, she started crying.
Okay. Is it true that she started to urinate when you picked her up?
No,
Is it true that you tossed her on a blanket?
incorrect.
And is it true that you said, good, now you can pee on your own blanket?
Incorrect.
Is it true that you slammed the bedroom door?
I did not.
Did you lock the bedroom door?
I did not.
Did you refuse to allow Ms. Borden to come in and get clothes for Oakley?
I did not.
What is your recollection of that date?
When I sat her in the living room right next to Mrs. Borden, I went back to my room. I did shut the door. I did not lock it. As I was getting back in bed and pulling the covers back up over my shoulder, Oakley knocked and I said, come in. Oakley came in, climbed in bed with me and went to sleep.
Do you recall Ms. Borden taking Oakley and leaving the home on that date?
Miss Borden was on a meeting on her laptop and she never left her seat from her desk.
Is it true that you have 2 televisions in your shop?
I used to.
And do you still have 2 televisions in your shop?
I do not. I took one up to the berry patch.
And is the other one still in your shop?
I do have one in the shop.
Is it true that you rarely attended church with Ms. Borden when you were residing together?
Incorrect.
Is it true that you tried to get Ms. Borden and Oakley to not attend church?
Never.
Is it true that Ms. Borden introduced you to that church?
I went to Crossroads probably a decade before I met Mrs. Borden.
Okay. Is it true that you skipped church to play golf?
I didn't know church was on Tuesdays.
Do you only play golf on Tuesdays?
That's correct.
Is it true that Ms. Borden purchased clothing for you when you were residing together?
Occasionally, not very often.
Is it true that she contributed to paying the utilities at the home?
Never.
Is it true that you were always gone at meet?
I guess I would object, Your Honor, again, that there was no testimony that she paid all the utilities at the home or any of the utilities.
Oh, I thought she testified that she contributed to the utilities. I apologize for that.
Okay, well, we'll take it for what it's worth. My recollection is she had referenced that and referenced some payment of utilities, but we'll have to look. I don't think that's dispositive on any issue the court's going to decide, though.
Mr. Higley, is it true that you were often gone at meal times when you resided together as a family?
Never. I always came up, whether I was doing maintenance on my equipment or mowing the lawn or whatever I was doing, we came up and had a family dinner together.
Is it true that you often stayed at Grand River Brewery after Ms. Borden and Oakley left on the days that you would go down?
It's incorrect.
Do you have a savings account or trust for Oakley?
I do. I have a couple of them. I don't know if you want me to say where.
No, that's fine.
Okay.
Have you ever had an issue with strangers coming onto your property?
Never.
Is it true that you've had equipment stolen out of your shop?
No.
Did Miss Borden have a house in Leslie when she was pregnant with Oakley?
She did.
And did you talk about moving there?
Never.
Is it true that you've allowed Oakley to play alone in your shop?
No,
And why do you laugh about that?
because I love enjoying the time with her. I'm always with her whenever she's on my property. I never let her out of my sight because I enjoy being with her.
Is it true that you had a keg in your shop when Ms. Borden moved out?
I did.
And is it true that Oakley was awake or around for times when you and your friends would play Cards Against Humanity?
I don't remember Oakley being around. It was always after we put her to bed.
Is it true that you had a lot of parties to watch sports at your house?
Just the Michigan State and Ohio State game.
And how many people would attend these parties?
3 if I was lucky, because we like to play euchre while watching the game.
So 4 including you, or 5 including Ms. Borden?
If Miss Borden was there, there would be 4 or maybe 5.
Do you recall November 7th of 2020? When you were up north with Ms. Borden?
I do.
And is it true that you went on a rant about how Ms. Borden would not talk to you?
I don't remember it being a rant. I remember it being a discussion that I wanted to find out why she would just walk away and not say anything.
And is it true that you left for a couple of hours?
This was due to my accident. It's hard for you to sleep after you have a head injury.
Well, this is 2020.
Oh. Okay, what was the question again?
Did you leave for a couple of hours?
Yes. I walked to cough because I was a little upset that she wouldn't speak to me.
Did you, on that date, did you yell at her, where's my effing beer?
Never.
Do you recall Tuesday, March 16th of 21?
Is counsel, your client's reviewing notes right now. You asked him if he could recall, and he picked up his notes.
I can recall it.
And your client was reviewing notes when she was testifying about the dates too. I mean, there's a lot of dates that she testified about.
But that was after I initially asked her if she remembered, and I believe she said yes, but I'm not going to argue about it. I'm sorry.
Go ahead.
Have you refreshed your recollection?
I have.
Okay. And do you recall Tuesday, March 16th
I do.
of 21? Was it true that Oakley was being cared for by your mom that day?
That's correct.
And is it true that you didn't pick up Oakley that day?
That is true.
And is it because you were at Grand River?
That is incorrect.
And do you know where you were?
I was doing an estimate, and that instant that she wanted me to pick her up, I was on my way back, and I could have been there in like 4 to 5 minutes.
Okay. Is it true that you asked Ms. Borden to pick up Oakley?
I said I could be there 4 to 5 minutes, and she says, I'm going around the circle. I'm right here. I can grab her. And I said, that's fine with me.
Okay. Do you recall Thursday, March 18th of 21?
I do not. I do not.
Okay. Do you recall in March of 21 if you were playing pool on a league?
You said 21?
Correct.
I haven't played on a league before Oakley was born. I stopped before that.
And were you subbing on pool leagues in 21?
I quit 100% before Oakley was born.
Okay. So the allegation that you came home drunk after playing pool on a league on March 18th, 21 is that true or false?
I haven't played on a league before 2018, so that's false.
Okay. And do you recall Saturday, March 20th of 21?
I do not.
Do you recall Sunday, March 21st of 21?
I do not.
Do you recall at any point in March of 2021 going to bed at 7:45 because you were drunk?
I guess,
7:45 p.m.
Your Honor, he can't remember the dates and he can't remember the incidents. So
Well, maybe the court will allow it because maybe the incident will recall, he'll be able to recall the date then.
As far as I know, every time Oakley was put to bed, I was there reading a book, snuggling in, tucking her in, helping her get her jammies on, whatever, every single night.
So do you recall any nights that you would go to bed early because you were drunk before she would go to bed?
Never drunk, but there are some times before I sold my snow plowing business that I might not have been there because I was snow plowing. But other than that, I was never too drunk to put my daughter to bed.
Okay. Do you recall going to your friend Mumi's house on April 12th of 21?
I do.
And is it true that you went there to work on a truck?
No, it's not true.
No. And why did you go there?
That night we were going to play, I can't remember if it was euchre or maybe it was Cards Against Humanity. One or the other.
Okay. And is it true that you came home drunk from his house?
I did not, because during the time we were playing, my vehicle didn't start because I needed to move it for his driveway. And I ended up focusing more on getting my vehicle repaired so that I could, get back home and get to work the next day.
Okay. Do you recall Tuesday, April 5th of 2022? So it would have been this approximately a year ago.
I do.
Okay. And if you refresh your recollection?
I have.
Okay. And on that date, did you tell Oakley that she had 8 minutes to watch a show and before you were going to turn the channel and watch a game?
I don't believe I told Oakley that. I asked Heather that, and we had a conversation about it.
Okay. And did you say anything along the lines, if you don't want me around, you can be alone, have a nice life, to Oakley?
Never.
And did you tell her to get the F back in the bedroom?
Never.
Is it true that you drank almost every day when you were with Heather?
Heck no, it's not.
And do you have any idea of how many days out of the week you would generally drink?
We did on, 3 Mondays out of the month. Heather and I did also. And then I would say 1 or 2 days a week, I would have 1 or 2 after work, but not every day. And there's sometimes when I've went a week and a half, I'm just busy. I have a lot going on. If I even got back to the shop to even have a beer, Oakley'd run out and we start playing. It wasn't every single day.
Do you recall Monday, August 29th of 22?
I do.
And did you go to a wedding that day?
I did not.
And was Ms. Borden upset because you were at a wedding instead of working at the restaurant?
Objection calls for speculation.
Well, I believe she testified about it.
Well, I'll overrule the objection. Go ahead.
She was very upset, due to the biggest day, for our restaurant. It's called the Blueberry Fest, and that people come from all states around, and it's very, very busy. And my cousin had a wedding that I told her about months in advance that I was going to.
But the wedding was on a Monday?
The wedding was on Saturday. 8/20 of 22, the wedding was on.
And so did you miss going to the restaurant on 8/20 of 22?
On 8/20 of 22, I did. I was at the restaurant in the morning, and midday I helped them prep for the Blueberry Fest and get all the pies and everything out, and did what I could. And then I waited till the very end, so I had to get going to get the wedding, and that's when I left. And I returned that night.
Do you recall September 3rd of 22?
I do.
And did you go to Grand River Brewery that day?
I did. I worked that day and put a full day in, or what I could, for my injury. And then that day they had the, I don't know what you want to call it, the band out on the road. They shut the road down. It's a big thing in town. And I did go down there to have dinner with one of my workers.
Okay. And is it true that when you were finished with dinner, you walked to your mom's home?
That's correct, because there's no parking within miles around, because people come from around, and I parked at my home so that I could have a parking spot. And I planned to stay the night there that night anyways.
Okay. And is it true that you were stumbling home when you came back to your mom's home?
That's incorrect, because when I got there, I did have a beer with dinner, and immediately I got a headache. So I stopped drinking and just drank water.
And is it true that you urinated in the yard of your mom's home that night?
That's incorrect.
And how are the street lights on her street?
There's one on the north corner and there's one on the south corner, but we have 2 units on each side of us, so it's very dark down it's kind of like a little alleyway where our driveway and houses.
Okay. And is it true that that when you got back to the house, you started your vehicle?
I did not.
And is it true that you were sitting in the vehicle when your neighbor came over?
I was not. My neighbor come walking across the street as I was halfway down the block to my house, and we started talking.
And where was Oakley that night?
Oakley was in the UP at a restaurant with Heather.
And is it true that you called Ms. Borden before the neighbor took you home?
I'm not sure if I called her before, but I know I called her after.
And is it true that you were slurring your words?
I was not slurring.
And were you intoxicated?
Like I said, I had my 1 beer and I got the headache from my injury, and I had water after that, so I don't believe so.
Okay, so Your Honor, he's rebutting his own testimony that he was intoxicated. The first time he testified, he said he was intoxicated that night. Now he's rebutting his own testimony. He said.
I'll allow it because the neighbor said that he was intoxicated, so I'll allow the answer.
Is it true that on September, well, first of all, do you recall September 28th and 29th, the weekend of September 28th and 29th of 22?
I do.
Is it true that you had parenting time that weekend?
I believe so.
And did you refuse to take your parenting time?
I did not.
And is it true that you invited someone named Tristan over to your house that weekend?
I did not.
Is it true that you asked Tristan to help you drain your keg?
I said it as a joke because it sat in there so long, it was flat. So I told him, if you want to come take the rest, go ahead. It's flat. It sat in there for like 6 months. And I don't know exactly how many, 4 to 6 months. And it was flat and gross. And I was in the hospital for a month and rehab for a month. And it was just bad. It was bad skunky beer.
Okay. Is it true that you called your daughter on Saturday, I believe it's a Saturday, September 29th of 22?
I call her every night.
Do you recall being intoxicated on that night?
I don't recall being intoxicated that night.
Is it true that you've had problems remembering names?
Who are you directing it to?
If you had problems since your accident, have you had trouble remembering names?
No,
Since your accident, have you had problems remembering conversations?
no,
Have you had problems remembering events?
incorrect.
Is it true that you've refused cognitive therapy?
That's incorrect.
And have you gone to any therapy, or psychological therapy?
I have, before I left Kalamazoo there, they set it all up for me and I did attend it. Heather wasn't around for a lot of them because she was in the UP when Lewis was taking care of my house.
I'm gonna object to as far as what my client was doing. That wasn't the question that was asked.
Okay,
Well, she testified that he wouldn't go, so
just move on, please.
I will. Is it true that you were invited to Oakley's parent-teacher conference for preschool?
Yes, it is true. The issue was that first of all, I didn't receive it, I should say. And so when I heard through the grapevine that there was a parent-teacher conference, I called the teacher and we got to talking and she said, I did send you an invite. And then I was like, I didn't receive it. And we finally found out that it went to my junk mail because the teacher said, I sent it to like 30 people at a time. So sometimes it goes in your junk mail, check your junk mail out. So when I found it there, I realized that I needed to add her to my normal one. So I did receive it, but it was in my junk mail. So I kind of didn't receive it.
Okay. Okay.
It's kind of weird, but.
Is it true that you agree that Oakley should attend a Young 5 kindergarten class in the fall?
That is true.
And is it true that you don't think it's important for Oakley to learn academic subjects?
I want her to learn everything she can.
Is it true that Ms. Borden invited you to an online parenting class?
Incorrect.
Is it true that you threatened Ms. Borden that you were going to take Oakley because you know the judge?
That's incorrect.
Is it true that you went to a football game on Heather's due date to have Oakley?
That is very true.
And did you drink that night?
I did not. We had a big, this is one time we did communicate. We had to talk about it for about 15 minutes that day because it was her due date. And it was actually the very first day Michigan ever had lights on the stadium. And Heather informed me that she knew that I wanted to go very bad. And we talked about it and she goes, I just don't feel like I'm going to have a kid. If you want to go just stick by your phone, let's keep communicating back and forth. So I parked in a special spot. I talked to her, or I text her, excuse me, every half hour. How you feeling? What's going on? I ended up leaving the game early. I parked in a spot where I could have a special exit out and walked to the game a further distance so that I could get out of there quick if I needed to. And again, we did leave the game early, so I got back home early, and she didn't have Oakley for another 8 days.
Do you pay attention to safety issues when you have Oakley?
I do.
Do you put sunscreen on her?
If we're outside.
Do you make her wear a life jacket?
100% of the time.
Okay. Do you make her sit in a car seat?
I'm against the car seat 100% if possible.
You're against the car seat?
I'm against putting her in there and taking her for long rides. But if she's in a vehicle, every time she's in a car seat, correct?
Okay.
So if you're taking her to the grocery store, do you require that she sit in a car seat?
Doesn't matter where I take her, she's always in a car seat.
Okay. Is it true that you had friends over to watch a football game when Heather went into labor?
We did have the rivalry game on Michigan State that day.
Okay. And were you drinking alcohol that day?
Nope, it was only noon and we were barbecuing.
Is it true that you didn't finish high school?
It is true, I didn't finish high school.
Okay. And what was the reason for that?
On my senior year, I had my brain surgery for my seizures, and I was medically out of there. And then I was able to go back to school. There was like 2 days or up to a week somewhere left of it. So I just didn't end up going back because I wouldn't have got the credits. And then every year on my birthday is the last day of school. So when school ended, I turned 18 and my family got me into the International Brotherhood of Electrical Workers as an apprentice. And I started my job, and I've done the same work since my 18th birthday as I'm still doing to this day.
Is it true that you had a brain injury from falling out of a tree?
That's incorrect.
Is it true that you refused to work in the restaurant up north in July, starting in July of 22?
There were times that I was feeling like I was going to pass out after my accident. And there was times where I could only work an hour or so and I had to return to bed. But the doctors weren't even releasing me back to work yet. And I was already starting to work for our restaurant because that's our busy time of year. And I was putting everything I could into it, but I felt lightheaded, like I'm going to pass out, and there's not much more that I could do. It was the same with the tree service for the next couple months.
Is it true that you've called to talk to Oakley when you've been intoxicated?
No, it's not.
Is it true that when you and Ms. Borden were living together that she didn't have to travel overnight for work very often?
She traveled to work all the time. That's all she ever does.
But overnight?
Overnight. I would say every 10 to 14 days she's at overnight somewhere.
Is it true that Ms. Borden was hospitalized in 2022?
Yes, it is. The day I returned home from the hospital, I had to drive her, which I wasn't supposed to drive, but I had to drive her to a medical center for her to get help.
And was she hospitalized for dehydration?
She was.
Is it true that Ms. Borden told you that she was changing Oakley's doctor to Dr. Shoemaker?
I didn't find out until I believe the third, what I've searched, the third meeting. I didn't find out until
the third appointment?
Appointment, sorry.
Is it true that you've missed most of Oakley's doctor's appointments?
With Heather, it is not true. It is not true at all. But I have missed a few that Heather said, hey, it's just a checkup. They're going to weigh her, measure her height. It's nothing. So I can take her if you're busy. But I have attended a lot of her doctor's appointments.
Okay. Is it true that you make beer at your house?
That's incorrect.
Have you ever made beer at your house?
I've never made beer at the house that I live in now since 2006. Okay. I did have the beer making kit that I did back in the day that Heather stored in the attic where Heather stored all of her possessions. And I'm sure she's seen it when she moved out and took a little note of the beer making kit.
Okay. Is it true that you have a distillery at your house?
I do have a distillery. My neighbor bought the distillery. I brought it over. We made one batch of distillery and nobody liked it or could drink it. And the dude said, I don't want the darn thing.
Your objection, Your Honor.
Sustained.
And it's going into a narrative. The question is it true you had a distillery? And then there's a narrative going on.
Okay.
Okay, I sustained it, Mr. Zoglio. Do you want me to change that?
No, thank you, Your Honor.
Okay, go ahead.
Do you still have the distillery at your house?
It is in the attic, correct?
Okay. Is it true that you didn't help choose the preschool that Oakley's attending?
Well, we visited the preschool that she's attending right now together and talked to the teacher and all of her assistants and toured the upstairs, downstairs playground. We met together and did that.
Is it true that you spend every weekend during college football season watching University of Michigan play?
No, I have a restaurant that I have to attend.
Is it true that you spend every weekend during March Madness watching basketball?
I don't watch maybe 10% of basketball.
Is it true that Heather bought you a relationship book?
It is true.
I have no further questions.
Okay, Mr. Zoglio, any cross?
Yes, thank you. What was the name of the relationship book, Mr. Higley?
I couldn't tell you.
Okay. Do you recall, did you read the relationship book?
I did not.
Okay. Could it be that you're mistaken and you never received a relationship book from my client?
I can give you the exact reason is she refuses to speak to me, and I just want to have a one-on-one conversation with so-called girlfriend.
That's not what I asked you. Could you be mistaken? Maybe you answered, maybe you said could be. Did you say that you never received a relationship book?
I agreed that I did receive a relationship book.
But you can't recall the name.
For the second time, no, I cannot.
Okay. Is it true that you went to the preschool?
Yes, it is.
What's the name of the preschool?
I don't remember.
Okay.
I have it on my phone, on my GPS. I have
Okay.
the teacher's number on my phone. I've contacted her. I text her. We email.
Okay. You can't remember the name, but yet you approved the preschool, right?
I did.
Okay. And just to clarify, you did make moonshine at your distillery? You did do that?
Well, you're incorrect. It's not my distillery, but I have done it one time in my life.
Okay. It's in your house though, right?
It is.
All right. And you said that you missed some doctor's appointments, but they were like regular checkup type appointments. Is that what you're saying?
Discussing it with Heather before I skipped it. Yes, we had a discussion before that and said it could be okay, and she'd inform me of what went on and give me the paperwork. Yes, I missed a call.
All right. Right.
On the agreement with your client that it was okay to.
Okay, and you just testified she informed you of what went on, right?
Before she moved, she didn't inform me when she moved of the new doctor because I thought she loved Shelley to death, and she moved doctor on me, and she did 2 appointments without my attention.
So the statement you just made prior to that about she informed you, that was incorrect. She didn't inform you of these appointments?
I believe I've answered that, buddy. She did at the Marshall doctor, at the doctor up in her town. No, she did not. There's 2 different doctors, so there's 2 different answers.
All right. So when you testified, when your counsel asked you that you missed regular appointments, you said you said on direct from your counsel that you missed these appointments, but you talked about them with Heather because that they were just regular things like weighing her and things like that. And you were okay with that because she informed you. Is that your testimony?
She was never sick. She never had a cough. She never had a fever. She never anything important. It was just her 18-month checkup, 24-month checkup.
Okay. Now, how did you find out it was an 18-month checkup and a 24-month checkup? How did you find that out?
Well, I passed algebra, so I kind of figured out how to count months.
Okay.
But I know her birth date, and I know the date it is today, so I can add.
Did Heather inform you of that ahead of time?
She did in Marshall.
All right, thank you.
Not at the other one.
All right, sir, you said you said that Heather was hospitalized and you drove her to the hospital. Remember that?
I do.
Okay, what date was that?
That was the day that I came home from the hospital. I don't have that date in front of me right now, but
All right.
that was, I can add it up here if you give me just a couple seconds.
Can you give me an approximate date?
Yes, I can. I'm going to say in the mid-20s of June, mid to late 20s of June.
Okay. So at that time you were still boyfriend, girlfriend, correct?
I don't know where she stands on that.
I'm asking you, you were still boyfriend, girlfriend in your opinion. I mean, you took her to the hospital, right?
I did.
So in your mind, you're still boyfriend, girlfriend.
Correct.
You said that you did some apprenticeship after while you were in high school, right?
Oh my
That's
God.
it.
Are you kidding me? This isn't even a divorce. I just dropped a bottle. This isn't even a divorce. This is a freaking just a custody case altogether. I'm gonna have to change the label. Well, no, that's just what we're leaving it called, but that's hilarious. They weren't even married before, and I think maybe that's why she's mad. Yeah, some women like to be called wifey. Anyways, let's keep going.
Incorrect.
Okay, what did you do? What did you do in high school? You talked about some electrical apprenticeship or something. What was that?
The day that I turned 18 on June 5th, I joined the local IBW Local 17. And I can't remember if it was 2 or 3 days later, once I become a IBW member and paid my dues, they hired me.
Who hired you?
The IBW hired me through DTE, Detroit Energy.
Okay. And that's why you didn't go back to school?
Yeah, I have 6 people in my family that are linemen, and that's what I intended on doing.
Oh, right. You went to lineman school, right?
After that, but not at the same time.
And you
I don't know if you know what an apprenticeship is, it means you learn on the job. That's what an apprentice is. So you get certified as you go along, and it's basically like a college, and then you get your certifications. You go from a apprentice to a journeyman to a foreman.
And you said you have how many people in your family that are linemen?
I believe there's 6 of us.
Okay. So after you had your brain surgery, did you ever consider going back and getting your GED from high school?
I didn't. I already had a full-time job and didn't need the certification, I guess.
Okay. You testified about an event on 10/13 where you and Heather talked about it, even though she was her due date, that you talked about it and you went to the U of M game, right?
We did have a conversation before I left.
Okay. And you're saying she gave you the go ahead to go to the game, correct?
That is correct.
Okay. And you went there and you just testified that you weren't drinking at the game, right?
I was not drinking at the game.
All right. What about before the game?
Before the what on her due date there?
Yeah, on 10/13 and 18. Yeah.
No, I didn't drink the whole day due to her being her due date.
Are you aware that on 10/13, sir, of 18, that you posted something on your Facebook of you and Tony drinking and you have a beer in your hand at the game? Are you aware of that?
Well, sir, I believe that I've had season tickets for about 20 years and there's no beer in the stadium. So I don't know what pictures you got.
Well, I've got a picture here, and I think this probably came from your Facebook or from your council, I think, submitted these pictures. And you're with Tony Johnson, and you say in here, getting close, go blue with Dale Higley. I can hold this up so you can see it.
Who's there?
There. That's you with a beer in your hand, right?
Looks like a bottle of something. I can't tell what it is.
Yeah, that's a beer.
Your Honor,
Just 'cause I-
is this testimony or is this questioning?
All right. Okay.
Ask a question, don't testify, please.
Absolutely not. You're absolutely not, Your Honor. You said it's a bottle of something, but you don't know what it is.
Can you prove that that's where we were? That's a picture.
Okay,
Pull out anywhere.
okay. Mr. Higley, you're answering questions, you're not asking them, so please just answer.
You said that you don't have any problems remembering names and events for your daughter, correct?
That's correct.
All right. And is it true that my client has sent you numerous texts about events between you and her and Oakley?
No, she skips me all the time. That's very false.
So you're saying so remember when you testified the first time and I went through all those text messages? You're saying she doesn't send you those texts?
I think I told you that the first time also.
Okay. So the stack of text messages that I held up, that's not between you and her?
They are. But those are just day-to-day talk, not events.
Okay. Are you aware, sir, that the last time you testified that on 9/3 that you were intoxicated?
I don't remember. Maybe I did. I guess. I don't know.
Okay. And so assuming that you did, and I'm not making this up, you're changing your testimony today to say you weren't intoxicated. Is that right?
My belief, I don't believe I was. I know I wasn't stumbling or spitting, and I didn't urinate in the yard.
Are you aware that on that day when I asked you about this, and after you said you were intoxicated, you said you were getting these headaches, and you had to drink a few times to make sure that that's what was giving you headaches? Do you remember saying that?
Yes.
So the witnesses that testified, Mr. and Mrs. Esser, they're making that whole thing up about you attempting to get in your car and drive and peeing in the yard. They just made all that up. Is that your testimony?
Well, I never seen the missus ever, so I believe she's made a lot up. But the mister, he did come to me as I was walking down the road, and we had a conversation as I got in the truck, to get my keys, because I was going to go on the front door. And that's when he stated he could give me a ride home.
He testified, he testified that you were in the car, and that you were in there and the car, and then the car was running, and that you were going to drive away, and he talked you out of driving. And you're saying today that's false.
That's correct.
All right. Do you know, are you familiar that when this husband and wife testified that they said they barely even knew you and Heather? Do you remember that?
Yes, I do.
And they're not motivated to lie in any kind of way?
I don't know if they are or not. That's their opinion.
All right. And your witness just testified, I think it was Mr. McKelvin. But let me ask you this. You've testified just now that you've never yelled at Oakley or Heather. You've never yelled at them. Did you remember?
Never said that. Heather and I fought constantly.
Okay. And
both yelled at each other.
In front of Oakley?
Yes. many times.
Because when council asked you if you ever yelled at Oakley, you said never just now.
I know I've raised my voice if she's walking by the road, or if she's done something we haven't asked her to, I might have raised my voice a little bit. There's a difference in raising your voice and yelling.
Now it's just raising your voice. Okay. Sir, you said you had a keg in your shop. Is it true that you had it in there for 7 years?
I don't think it was 7 years.
How many years?
I would say probably 5.
And you said that you were always home at meal times because you had family meals and you would never come home drunk from the bar. Is that right?
I would go there from occasionally, like twice a month, from 3 to 5.
Do you remember testifying for the first time you said that after everybody was, or after Oakley was in bed, that you would go to the bar?
Occasionally. I made sure that we ate, she took a bath, we went to bed, I read her a book, and then after they went to bed at 9 o'clock, I don't know. I don't know about you if you go to bed at 9, but sometimes I like to do things and have a life. Occasionally, a couple times a month.
You like to have a life. Okay. Sir, during council asked you about a bunch of dates and you went through them. I think you looked at your notebook or something. Okay. When you went through these dates, isn't it true that testimony came out from my client that she had a journal of all these dates and what occurred? Is that right?
So you're telling me that my journal doesn't count? Because I also have a journal.
Okay. I'm not going to answer your question, sir. I just asked that you answer mine. Isn't it true that my client said that she had a journal of all these dates?
I believe she did state that.
And at the time these events happened, she recorded in her journal about these events, right?
I don't know if she did or not.
Okay.
I didn't hear her ever do it.
Did you at the time of all of these events that she testified to, did you keep a journal at that time?
I did.
You kept a journal. Okay. So if that's
time I did.
So if that's the case, why didn't you bring these events up the first time you testified?
I have.
No.
Well, because on my journal, it's not the same as her journal. I look up the dates that she stated, and they were great days. We didn't have a fight. We didn't argue. Nobody yelled. It just went smooth and easy like a normal couple did. That's what my journal says.
But you didn't, the first time you testified, sir, you did not mention a journal. Is that right?
Did you ask?
I am asking you if you mentioned a journal. The first time you testified, did you mention a journal?
I believe I did have a journal that I have dates that I've stated.
So you're saying the first time you testified that you did mention that you had a journal. Is that what you're saying?
I don't know if I mentioned the journal, the J word, but I did give you dates and times and stuff on events. That's kind of obvious that I have a record.
Isn't it true that you just blanketly went through these events and you just, for most of them, said incorrect or false? Isn't that right?
I did. I answered the question my attorney asked me.
So is it your testimony here today that as Miss Borden, as these events were occurring and Miss Borden was writing these events in her journal, that they were all false?
I haven't seen her journal, so I wouldn't be able to tell you if they're all false.
on the answers that you gave where you said false and incorrect on the dates and the events that happened, is it your testimony here today that she basically, that those are all false and that she lied in her journal? Is that your testimony?
Yeah, I think she's pushing it way overbound and out of bounds. They're false. The statements that she said.
So all of her detailed descriptions are false. That's right?
Every question that I asked and I said false, I mean it was false.
Okay. I have one moment, Your Honor, please.
Okay.
Damn, we missed the journal reading. I am so mad at that stalker. You have no idea.
Your Honor, I have no further questions at this time.
Okay. Ms. McNiff, any redirect?
Briefly, Mr. Higley, did you ever see Ms. Borden write in a journal when you were together?
Never.
I have nothing further.
Okay. Anything else, Mr. Zoglio?
No other questions for Mr. Higley, Your Honor.
Okay. Okay, thank you. Ms. McNiff, any more rebuttal witnesses?
Nothing further, Your Honor.
Okay. Okay, that, Mr. Zoglio, do you have any rebuttal?
Your Honor, I do have some rebuttal based on what Mr. Higley said from my client. But if we could have maybe a 10-minute break or 15-minute break to use the restroom, my client has to use the restroom.
Okay, why don't we take a 10-minute recess and we'll reconvene at about right around 10:10.
We will reconvene right now, as a matter of fact. No potty breaks for you, lady. So we will finally hear her speak, guys. I believe it might happen here. This is the last part of this case. This is all we have got. It is.
Yeah, must have talked to everybody that knows you, huh?
I think that's got to be it.
Yeah, that's good. Well, and we mentioned it too, didn't we, during the on the record about how you were concerned?
We did, and I think maybe that helped.
Good.
Oh, good.
Yeah.
Hopefully it did.
Hold on, I'm almost there.
Yeah, hopefully you get relief from that because nobody wants that hanging over their heads.
Heck no.
Absolutely.
Okay. We are back on the records.
Okay. Mr. Zoglio, any rebuttal?
I have a brief rebuttal, Your Honor. I'd call my client.
Okay. Ms. Borden, you're still under oath, okay?
Ms. Borden, Mr. Higley just testified that he golfed on Tuesdays only. Is that accurate?
No,
He golfed what other day did he golf?
he would do his golf league on Tuesdays and rarely miss that. And then he would golf with Matt, his buddy, on Sundays quite often. And a few times, he said he had golf outings with Mike Martinez. I don't know if those happened.
Okay. And would he be drinking at those outings on
Yes.
Tuesdays and Sundays?
Yes.
He also talked about a fight that you and him got in, or I guess it was an oral argument between you two on 11/7 of 2020. Is that accurate?
The date's accurate, but I don't fight with him. He was just yelling at me.
Okay. And he said he walked away that day?
Yeah, he finally walked away. He was gone a couple hours.
And had he been drinking?
Yes.
And was he intoxicated?
I think so. The way he was talking to me when he yelled, "Where's my effing beer?" When I saw him outside, I felt he was drunk.
Okay. And how long was he gone?
He was gone a couple hours, a couple being like maybe 2 hours. Oakley and I had dinner, we cleaned up, we'd watched an entire movie, and he was not there for any of that.
Do you remember him testifying an event that occurred on 11/20/2021?
11/20.
Or is that 2020?
Is it the Thanksgiving incident
I
at his
believe-
uncle's house?
Believe so, yes.
Yeah, it was the 28th.
Okay. And you heard his statements today about that?
Yeah.
What was untrue about what he said, if anything?
Well, first of all, I testified with the whole truth. So he said everything was untrue that I had said. And so I'll just start with, they were smoking pot, drinking beer, and smoking cigarettes in his uncle's shop where he keeps his pigeons. And he did want Oakley to go in there and hang out with them, but I didn't want that. It's not a good environment for her. He said that I didn't take her on a nature walk. I mean,
And did you do that?
of course, yeah. I mean,
Why did you do that?
Oakley needed something to do because we weren't going to be in the shop sitting with everybody else who was smoking and drinking. So we did a lot of things. We went on a nature walk. We watched TV shows on my phone. We hung out in their living room and looked at all their trinkets and figurines. We did everything we could to keep busy.
Okay. He testified about some events in March of 21, correct?
Yeah.
Specifically about a bedtime incident at 7:45 p.m.
Yeah.
Was that true what he said?
Well, I think he said that he wasn't in bed at 7.
Sorry, I'm gonna have to pause it there. I want everybody in the chat immediately, please write down what you were doing in March of 2021. Was it March 21st of 2021 at 7:45 p.m.? Please put that in the chat. Put that in the chat. I know you all remember. Of course we do. Of course we do, Zoglio. We remember that. Not? What the hell kind of questions are these? These lawyers suck.
45 that night because he liked to go and do things.
Okay. Is that true?
No, he was in bed that night at 7:45 because he'd been drinking the day before and he was exhausted.
Okay. How much drinking did you do the day before?
Drunk, to the point of being drunk and slurring and stumbling.
He also testified that he's always there at bedtime to read a story to Oakley and put her to bed. Is that true?
Well, yeah, how can you use the word always?
Of course
No
we do.
one's always there.
Okay.
Of course we
Was
do,
he there the
Zoglio.
majority of
We
the
remember
time?
that.
No.
Not.
Who put her to bed usually?
I did. He would ask me to let him know when it was her bedtime if he was down in the shop drinking with his buddies. And I did let him know. And on those dates, some of the time he would come up and put her to bed with me.
Okay. Do you remember him testifying to events that occurred on 3/16 of 2021? And when I say testifying, I'm talking about today.
Can you refresh me on that?
Oakley was with your mom and that particular day?
Okay. Can I look at my notes real quick?
Yes.
Yeah, I remember that.
Okay, can you tell the court what happened?
Well, he said that he just testified that he didn't pick up Oakley, that he wasn't supposed to. I believe that's what he said on that date because she was at his mom's house. And what he had told me was that he was at Marengo Township doing an estimate, which is not 4 minutes away from his mom's house, like he said. And then he said that he had asked me to get Oakley. It's all in my texts, and I can talk about those if you want, but he asked me to get Oakley. And so I did. And then we went home and we were waiting for him, and he didn't get home till later that evening, I think around 8 o'clock. And it turns out that he had been at the brewery bidding on tree service equipment from a company called Ailes that had gone out of business. And he wanted to buy a chip truck. So he was sitting there on his phone bidding. He wasn't actually at the township doing estimates. And then on top of that, when he got home, he went over to his neighbor Mike's and was playing pool.
Do you know if he was drinking at the brewery or at the neighbor Mike's?
I didn't see him at the brewery, but it is typical for him to drink at the brewery. And then at the neighbor Mike's, I don't know if he was drinking. All I know is he came home drunk. So where he was drinking, I don't know.
All right. Do you remember him testifying about a 4/11/21 incident or 4/12/21 incident?
Is that where he was going to go play cards at his friend Mooney's?
Yes, and something about his truck broke down. He said that.
Yeah.
Is that how that is what he said accurate?
No, he has his time frame jumbled up. So what actually happened was on 4/11, he and I were supposed to have a date night that night, and we stopped at his friend Mooney's house. That's his nickname. It's his last name. And instead of going on a date, he hung around and drank with Mooney, and I sat in Mooney's living room. And when we went to leave, the truck would not start. So the truck stayed at Mooney's house overnight. And the next day, he was supposed to hang out with Oakley, and she begged him not to go, but he had to go pick up his truck because he was worried about it sitting there. And so he went around 3 p.m. that day to go get his truck from Mooney's house. And he said he'd be right back to Oakley, but he didn't come right back. He was playing cards. He told me he was just picking up the truck, but it turns out he was playing cards and drinking that day, like he said. And so he didn't get home till later that evening, and he was drunk and slurring his speech.
Do you have text messages to back that up, or is there no text messages regarding this incident?
Yeah, we around 6:30, I texted. It was like 3 hours later after he left, and I texted him to ask him where he was, and he didn't reply. I texted Mooney, and Mooney replied and said that he was there and that they were working on the truck, but it had been raining. It was a huge thunderstorm that day. So if he was outside working on his truck, he would have been soaking wet when he got home, and he definitely was
not. Dale also testified today addressing the issue of when you testified previously about Oakley when she peed on her blanket. Do you remember that?
Yeah.
And that was approximately 8/23/22.
Yep, it was.
He made the statement that you stayed there on the computer, and you were in your you were in the house the whole time. Is that correct?
Well, I was in the house for the whole incident. I wasn't working. It was in the afternoon, and there's no office. It's just an apartment. The desk is in the living room. And he said that he said that what I said, which was that Oakley was hyperextending the door and he was trying to sleep. So I was watching Oakley, and I had asked her not to do it. Then he said he did not grab her aggressively, and that she did not pee, and that he did not toss her down, but he did all of those things. And I was there for the whole thing. And what happened after that is I took Oakley out on the porch, and she didn't have any pants on because she had peed in her pants. So I took her out on the porch, and I was consoling her and trying to get her away from that environment. And then I went back in and I found some pants out of the laundry, dirty pants, and I put them on her, and we left. And we went to buy her some new underwear, and we went out for Chinese food. And Dale and I texted back and forth that at that point, there's text to show what happened.
Yeah.
He asked me to bring him food.
And in one of his texts at 7:40 p.m.
Your Honor, I'm going to object if
Okay.
counsel is going to testify and read this text.
I'll rephrase. You just testified that he said he was trying to find out where you guys were.
Yeah,
All right. Did he send you a text?
yeah, he did. He asked
All right.
where we were and if we could bring him food.
Okay. And if I showed you the text, would that refresh your memory on what time that was?
Yeah,
All right. Can you look at that, please?
yeah. I'm not allowed to read it, just to talk about the time frame.
I think you can tell the court what he said.
Yeah, well, he said at 7:40, he said, "Where are you guys now?" And I said, "We're at Chinese." And he said, "It must be really good. You guys left at 5." And I said, we turned some pop cans. I bought some stuff at Myers, that being the underwear, and we're just relaxing at the Chinese food. What do you want me to bring you? And the conversation went on from there.
Okay.
So
Why did you end up leaving?
because he'd just been extremely violent and aggressive with Oakley, and we're both very upset. And I have to find a way to indicate to her that treatment's not okay, and that was one of the ways, is to get out of there.
Okay. Now, you just to intervene here, you actually recorded all these events in your journal, correct?
I did.
And when you recorded these events in your journal, were they accurate at the time that you recorded them?
Yeah, I recorded them at the exact time that they happened. So typically I was recording my journal at the end of the day when Oakley was sleeping and Dale was not around.
So this isn't something that you fabricated for these custody hearings, is that right?
It's all date and time stamped. My journal is real time. I
Okay.
still keep a journal.
Okay. Now, just moving on here, getting towards the end, he was talking about an event that occurred on 8/20 and 8/29. Do you remember his testimony just then?
Yeah, his attorney had asked him about the events on 8/29/22, and if you remember going to a wedding, but they had the date wrong. The wedding was on 8/20/22, and I think they corrected that later. And yeah, he did. He was up in the UP with us. He wanted to go to his cousin's wedding, and he thought it was in Traverse City, just a few hours from the UP, or in Paradise where we were. But when he punched the address into his phone, it turned out to be 5.5 hours away. So he was racing down to the wedding. He took Oakley with him. He's racing down there to get to the wedding in New Lothrop, and then he stayed for a while, and then he turned around and drove her back to the UP, another 5.5 hours back.
Did he tell you why he did that way?
Because he really wanted to attend the wedding, and he wanted Oaks to be there, even though it was like, for all his complaints about driving, it was a ridiculous amount of driving.
Okay. And when that wedding was on 8/20, right?
8/20.
Were the events on 8/29 something different?
Yeah.
What happened on 8/29 that was different?
Okay, look at my notes real quick.
Sure.
Mr. Zoglio, if we could, obviously this is rebuttal. Could we confine ourselves to rebuttal? I know she testified to all this stuff previously. I don't want to go through it again and be redundant.
Certainly, Your Honor. And I'm finishing up. I'm wrapping it up too.
Okay.
Okay, on that date, I was trying to talk to him about the Labor Day weekend at the restaurant, and if he was gonna come up and work, because he was starting to not come up with us on the weekends. And he wouldn't answer it. And he asked me where the money was for the weekend before, because he wanted to get paid for being at the restaurant that weekend before. And basically I had to remind him that he left that weekend. He didn't remember that he'd gone to the wedding that weekend. And so I had to explain it to him and then tell him what, like, if he wanted money, what it would be based on the hours he was actually there. And yeah, just in general, it was a conversation about whether or not he was going to help with the restaurant anymore.
All right. And while we're on that subject, he just testified on direct from his client just now that he always went to the restaurant. He had to work there. Is that accurate?
No.
Okay. Did he go there in September of 22?
There were at least 3 of the 4 weekends in that month that he did not come.
Okay. And leaving you to do all the work yourself.
Yeah.
Okay.
He had various excuses, like I have storm work. I have to catch up because I was not working the month of June. And just other things, but what he was doing was going to football games and going to concerts
and drinking.
All
right. So, and then he also talked about, I asked him some questions about the keg. And did he ever apologize to you about the keg, about draining down the keg?
Yeah, he did. So he had went to the brewery. So what happened was, and I'll make it short. He was supposed to go to the brewery that week, or the restaurant that weekend to help. And he had been watching Oakley because I was working at the Kellogg Center that week. So he had been watching Oakley instead of having her come with me to work. And then he and she were going to drive up, and then we were all getting in the car to go to the UP that weekend. But when he arrived with Oakley, he dropped her off and said, "I'm sorry, it's short notice. I'm not coming with you to the UP." And I said, "Well, what am I going to do?" He had planned to watch Oakley in the UP while I worked at the restaurant. And so I kind of had to like pivot quick and find someone to care for Oakley. And so I did. I'm keeping it short. There's other things that happened, but I did. I asked my mom. She came last minute to the UP. And then that instead of going home that night, I guess he went to the brewery and he saw Tristan, his old employee there. And he invited him back to his house to.
Your Honor, I'm just going to object. I don't know where the knowledge of this comes from. It sounds like it may be hearsay.
Sustained.
All right. I think you made your point on that.
Okay. Yeah, he called me and apologized to Oakley and I about the drunken call the night before. And he explained that he was just trying to get rid of his keg and make some changes. And I texted him back later that day and said, "Thanks for the apology about, and I'm glad you're getting rid of the keg."
Okay. He claimed too that when he testified just now that about your traveling for work, said you travel, I think he said 10 out of 14 days. Is that accurate?
He said I travel every 10 to 14 days overnight for work.
Is that accurate?
No.
Okay.
It's a gross exaggeration.
Okay. How much do you travel overnight for work?
And I already testified to this, and it's the truth. And I have my work calendar. I have texts between him and I. I traveled between December of 22 and today, overnight for work 4 times.
Okay. So 4 times since December of 22?
Yeah, with Oakley. I had 2 more overnights that I did that Dale watched Oakley instead of, he claimed that I took her with me, but he was actually watching her while I was overnight.
And I think you already testified to that.
Yeah.
All right. Your Honor, I don't think I have any other questions, just rebuttal. So I want to adhere to what the court
okay. Ms. McNiff, any cross?
No, Your Honor.
Okay, thank you. Any additional rebuttal, Mr. Zoglio?
No, Your Honor. Thank you.
Okay. So it looks like that concludes our proofs in this matter. Ms. McNiff, closing argument.
Yes, Your Honor. Your Honor, from the testimony of all of the witnesses that the court has heard over the last 3 days of trial, the court can see that this party's child looks to both parents for comfort, discipline, and the necessities of life. Both of these parents have the ability to the financial ability to care for the child. Oakley lacks for nothing in terms of food, clothing, shelter, medical care, and educational needs. Both of these parents take her to church. Both parents agree on not using corporal punishment. This child is well loved by both of her parents and their extended families and their friends. Both parents read her books, they take her to activities, and they are both involved and caring parents. The issues that are driving the conflict between these parties are really a combination of a lack of communication and differences in perspective regarding who should be caring for Oakley when the parents are working. Ms. Borden prefers Oakley to be in the care of her mother, who admitted that she physically cannot get on the floor with Oakley or pick her up. And perhaps it's understandable that a first-time parent would prefer her own parent to watch her child. However, Mr. Higley's concern is that in the event of an emergency, Mrs. Borden's mother may have difficulties reacting quickly. He's concerned that there's no vehicle available to Ms. Borden's mother. If there was an emergency, he's concerned about the safety of Ms. Terry Borden's home. He's concerned if something happened to Oakley, that Ms. Terry Borden wouldn't be able to pick her up off the floor and take care of her. He would prefer to have Oakley in licensed childcare if the parties are unavailable. He's researched childcare providers and has provided the name of a licensed childcare provider in Marshall that he would like to have Oakley cared for. He would also prefer to have people who are trained to care for Oakley in an emergency situation and who are physically able to do so. Terry Borden had to be pressed during cross-examination to say that in an emergency that she would call Mr. Higley. Mr. Higley should be called in the event of an emergency situation with Oakley, whether Oakley is being cared for by a grandma or whether Oakley is being cared for by licensed daycare or mom. He would prefer to let grandma be grandma, bake cookies, do things like that, rather than be one of the primary caregivers for 7 to 8 hours a couple times a week for Oakley. Mr. Higley acknowledges that Oakley is advanced in academic studies for her age, but he does worry about her social skills with other children. Oakley's days until she started preschool, not that long ago, were primarily spent in the company of adults. She was with grandma, she was with mom, she was with family, friends, but not as many children as Mr. Higley would like to see her be around in order to learn how to interact with her peers. He also has concerns about Oakley having to be in the car for hours, whether driving to work sites with mom or going back and forth to Upper Peninsula to check on the party's restaurant. Rather than taking Oakley on overnight work trips, he would prefer that Oakley be at home with him, not in the hotel. Ms. Borden's primary complaint about Mr. Higley seems to be that he drinks too much and that he has a temper. Our response to that is that first, Mr. Higley has little interest in drinking since his accident has rendered him almost unable to drink due to the headaches that are now associated with drinking. In fact, he has no objection to a mutual prohibition on drinking alcohol or the use of marijuana when the parties have Oakley. The court has certainly resolved concerns about substance abuse in cases that have much more serious allegations of substance abuse than have been raised in this case. If drinking were more important than his daughter, Mr. Higley wouldn't make the offer to accept a mutual prohibition on the use of alcohol when the parties have the care of Oakley. Ms. Borden is the only person in this case who has testified that Mr. Higley has directed anger at Oakley. And her testimony, quite frankly, is self-serving. Everyone else, including Ms. Borden's sister and mother, have testified they have not seen Mr. Higley act in any way other than as a doting father towards Oakley. The testimony of all of his witnesses were absolutely clear that he adores this child, that he does not direct anger at her, that she seeks him for comfort when she's upset, and that he is attentive to her needs above and beyond anyone else's when she's in his presence. Your Honor, this is not a divorce, it's a custody matter, and there are likely many reasons why these parties didn't marry. However, they do have a beautiful, even precocious child who clearly they both adore. Mr. Higley and his witnesses have not criticized Ms. Borden's parenting. In fact, they've testified that she's a good mom. The fact that the parties don't get along well enough with each other to continue in a relationship is not a good enough reason for Mr. Higley to be relegated to a weekend parent. There's been absolutely no testimony from anyone other than Ms. Borden that Mr. Higley has used corporal punishment with Oakley. All of the witnesses, including Ms. Borden, testified that Oakley is always happy to see her father, that she doesn't resist parenting time, that they have fun together, that she's glad to see him. That when Mr. Higley has Oakley, that he doesn't pay attention to anyone but her. It's unfortunate that Ms. Borden has chosen to move when she owns a residence in Marshall that has a unit that isn't even rented. These parties may not agree on everything, but they got along well enough to spend New Year's Eve together for the benefit of their daughter. They got along well enough to tour a preschool and make a decision about what preschool Oakley would go to. They've been able to rearrange schedules and change parenting time when it's been in Oakley's best interest. They've been able to communicate with each other through text message without the need for our family wizard or without the need for a PPO. They are able to be in each other's company, and they are able to make decisions together. Both of these parents have shown a willingness to put Oakley first and to sacrifice for her. We believe that the best situation for Oakley would be a joint physical custody situation. Mr. Higley has requested sole physical custody, not because he thinks that is necessarily the best thing for Oakley, but because Ms. Borden has moved from Marshall and he has concerns that the court can't fashion a joint custody situation that would make sense given the distance between the parties, and that physical distance might hinder the parties' ability to have joint physical custody. However, this court has ordered joint physical custody in situations where parents live even farther apart by awarding one parent all of the weekends and holidays and vacation periods of time, and the other parent primarily the school periods of time. While Mr. Higley would like nothing more than to see Oakley daily, he understands that his preference may be impossible with the current living arrangements of the parties. However, we again point out to the court that Ms. Borden does have an empty rental unit in Marshall that she could utilize on different times. If she were to come on an alternating week basis, she could be here. We are asking this court to award Mr. Borden significant time with his daughter, to award the parties a joint legal custody, certainly to award them preferably joint physical custody so that they both have significant time with Oakley, and Oakley has the benefit of both parents raising her. We believe that this could be fashioned so that both parties can be equal and involve parents with Oakley. Thank you.
Okay, thank you. Mr. Zoglio?
Thank you, Your Honor. Your Honor, counsel made some statements and you know, I don't disagree with every single one of her statements. I know that my client, there was testimony that my client is a good mom, and there was that issue that came up several times. You know, the problem is that there was a lot of things that that came out of this hearing that have caused a significant amount of alarm for my client, and hopefully the court can see these things. I mean, we're mainly here because you know, Mr. Higley had testified that he wants physical custody as long as Heather lives by him. It's okay for her to have joint custody. Again, that seems to be his mentality. Although a lot of the witnesses really didn't bash either party that bad, we feel that a lot of Mr. Higley's witnesses were coach self-serving witnesses that really understated the amount of drinking that took place. And they also really don't know what takes place on a daily day basis. And so, you know, there were so many misrepresentations to the court, I couldn't quite, you know, count them all. But, you know, there are a few things that I want to point out. You know, I mean, obviously, Mr. Higley has an opinion about things, but one of the things that's concerning is that we believe that he does not want Oakley to have a really good relationship with my client's side of the family. I mean, he called his mom the master babysitter. and he called my client's mom a cripple. Even though, you know, there was a time that she actually watched his child for him while he was in a motorcycle accident. And, you know, Mr. Higley also is trying to paint a picture of Heather Borden like she broke up with me after I got into the accident. All the testimony of that was all presented against that, including by his own testimony, even today, where he said that they were still, in his mind, you know, boyfriend, girlfriend at the time that she had to go, that Heather had to go to the hospital. You know, Mr. Higley, it's easy for him to say these things now, but he made a lot of misrepresentations to the court regarding his substance abuse issues and his degree of injury, including calling his injury a concussion. But then later it was termed that he had a brain bleed. And that was from Mr. Higley's own testimony. He was in ICU for several days. You know, as far as I'm concerned, you know, a 0.03 is too much to drink before getting on a motorcycle. That's halfway to drunk driving. 0.08 is considered drunk driving. And if you're going to drive a motorcycle, you shouldn't be drinking at all. And to say you only had a beer and a half, well, he had more than a beer and a half to be 0.03. But, you know, I'm not the expert on it. I think the court can draw its own conclusions. He said he's an American citizen who can do what he wants. But, you know, he admitted to nearly 6 different bars during the party's relationship. And I think he testified to something different today. But we had 28 visits to drinking establishments in 2022 alone. And that doesn't include the pool leagues and the golf leagues and the new golf league he signed up for now, as well as the University of Michigan games where he was drinking. Which, by the way, today, we directly showed that he misrepresented to the court that he was not drinking on the date that Heather was due, and that she gave him the blessing to go to the U of M game. But yet we showed a picture of him with a beer in his hand, and he said, "Oh, that's a bottle of something." I mean, again, the understating of the drinking. I think the court can draw its own testimony regarding that. The witnesses that were brought in, Mr. Sill, Mr. Lewis, provided some interesting testimony. Mr. Sill provided some testimony today about the amount of drinking during the pool leagues, which was actually quite surprising that he was forthright about that. Because the first time he testified, he said, well, Dale doesn't drink as much as he used to. And yet he admitted to smoking marijuana and drinking outside the house and going to these keg parties. Mr. Lewis, I think, his nickname was Lucky. He'd be kind of an easy person to discredit because of his felony record and because he was investigated for some type of child crime. But I wanted to point out to the court something interesting that he said. He said that he felt like the parenting styles between my client and Mr. Higley were different. They had different standards. He called my client a housewife type. And so I looked that up. And while it's not part of actually, you know, it wasn't specifically defined. I mean, a housewife is someone who manages the family and manages household affairs and doing housework while the husband goes out and work. And this is a little similar here because bottom line is my client is the one that took care of this child, period. When the parties were together and now. And so they don't really dispute some of those things. Lucky also talked about the red glasses that they would drink at the keg parties and such. And, you know, he also said, well, his daughter is his whole world, Mr. Higley's whole world. But yet, you know, testimony came out that he doesn't even provide health insurance for his daughter, and money and certain other things. So, you know, Your Honor, I also think that, you know, some of these individuals that testified, even the police officer, really understated his drinking. But the police officer admitted that he was that Dale, he went to parties and things. Dale was a responsible business owner, but he admitted that he's pulled people over for drunk driving that are responsible business owners. And so, Chris also admitted, Chris Hugg, the officer, also admitted that he was never told about the driving drunk episode on September 3rd of 2022. Which, by the way, Mr. Higley changed his testimony on that. And first time he testified, he said he was intoxicated. Now he says he wasn't. But the court can draw its own conclusion. Michael Martinez was a witness called by Dale Higley, who told his own friend to go to Alcoholics Anonymous. You should go to Alcoholics Anonymous. But, Dale Higley never went because he's testified that he doesn't have a problem. So he doesn't feel like the need to go. Jennifer Dye was a friend of Dale's, but is also never going to be a caregiver of Oakley and is not a caregiver. But she also understated his drinking as well. The witnesses today, Your Honor, just in my mind, just confirmed the drinking, really, and the multiple situations of drinking for him. We called Gretchen and Tim Esser. The court heard the testimony. Mr. Higley was trying to get in his car and drive drunk. And Tim Esser went over there and stopped him. Although Tim Esser also said he was annoyed by the fact that Mr. Higley was disparaging his girlfriend in front of him, and he didn't care to hear it. It's really none of his business. He was just trying to be a good Samaritan and drive a drunk person home. Cassie Thalen testified on, and she's like a preschool teacher, administrator type. She works closely with Heather. She also testified that she had to go up to the UP to pick up her sister because the two of them got into an argument, and my client was left up there. Also had made comments about when Dale was alone with her, that he also made disparaging comments about Heather to her, his own sister. You would think that he would not do that. Your Honor, there seems to be a focus here on the grandmother in this situation, Terry Borden. It's interesting because Terry Borden, a loving grandmother, really came in the picture and really tried to help this couple with their kid when they're with their child when they needed it. Being classified as a cripple, but she by Mr. Higley, but she drives, cooks, cleans, walks, runs her own errands, does crafts. She's independent. She cooks and cleans for herself. She lives next door to Sparrow Hospital. I think 4 minutes from my client when my client goes to work. And there was also testimony about her not being able to get up and run. Well, people at her age, I don't know anybody that can run at that age. But there are people in their 50s and 60s that can't run at all, period. But the interesting thing is that even though Mr. Higley's mom was unfortunately had cancer and was in a bad situation, my client made sure that she still got visitation time with Oakley. And that speaks volumes for her. And has never said anything disparaging. Even though her journal reflects things that were said between them, always respected her during the time and never badmouthed her. And again, the amount of time that she helped the parties and to be critical of her is just really not in its place. But the main compelling testimony in this case, Your Honor, came from my client. My client had kept a journal. She had specific dates, times events accurate. She just didn't stand up and say, no, that didn't happen. False, incorrect. She didn't do that. She gave specific examples with specific texts and specific things because she was recording these events, because she's always done that. And I can tell you as a client, I was almost borderline concerned myself with all the paperwork I got from my client during this case. Okay, that's just the way she is. She keeps paperwork, she keeps records of things, which is actually a good thing. But it just got to be a lot. There's so many incidences, there's no way that we could have testified to them all. But there's a few high points. The trust between Oakley is prevalent. Heather is the primary parent to establish healthy boundaries. She's the one that taught respectful behavior. She's the one the child comes to when it's sick, scared, or worried. And it's always been that way. She believes in positive discipline, okay? Not being permissive and then exploding like she testified that Mr. Higley did. She talks about teaching kindness and teaching her ABCs and what to do in emergencies, cleanliness, hygiene for a young girl, okay? She tried to work with Mr. Higley on how to install car seats and stuff. But there were so many incidents of the two of them arguing about the drinking habits and being disruptive, going to, I can't even name all the dates, going to pool, stumbling home at 3 a.m., drinking at friend's house, drinking before the motorcycle accident, partying at the U of M games, going to pool leagues, drinking, even post motorcycle accident, drinking, like nearly 3 months later to levels of intoxication, calling drunk, and the incidents also where he would come and get frustrated and yell at his daughter and hold her down. Those events also came through. The big thing that my client would like to say is that, yes, absolutely, this child loves her father. I think my client said she loves her dad. But the concern is going forward is, what is that bond really like? Is it a healthy bond, or is it like a fearful type bond? The example of 3/21/2020, where she accidentally knocked over a beer. I can't tell you how many times kids will knock over beers when they're not beers, but anything, drinks, or spill something when they're young. It happens all the time. The level of frustration that my client had to deal with, and playing sort of taking her daughter and sort of rescuing her from these situations. Coming home drunk, 4-2, grabbing her so aggressively that she peed her pants on 8/23/2022. Again, if we're talking about the love and affection, I think that these factors favor my client, as well as the established custodial environment. It's obvious in this case. And as far as the religion and the capacity to do guidance and continue education, Your Honor, my client testified she enrolled Oakley in Kids Church. She has attendance records for Crossroads and Riverview. She said that during the time that they lived together, that Dale would very rarely attend church. And she was the one that taught her how to use utensils and brush her teeth and tie her shoes. Heather helped Oakley to read and write, really concentrating on education. It's interesting. The first time Mr. Higley testified, he didn't, and some of his witnesses also supported this, he really didn't concentrate on education. He says, in fact, that it wasn't that important and the books things weren't that important. But today he changed the testimony again. But bottom line is, when it comes to the school, my client found the preschool. He couldn't remember the name of it. And she's the one that has taken all the initiative with school and all of that, Your Honor. And she will definitely let him know about any school events. If that child continues school in the Mason area or Lansing area, she will continue to let him know. She's, as far as the capacity, Your Honor, she's had the same job for 7 years. And she's had the same income, which is, it's consistent. And she has a college education. and Mr. Higley doesn't. Now, that being said, that doesn't mean that he can't be a good parent just because of that. This is only one factor, but his concentration, again, is really not on school and education. Okay. And as far as bedtime and dietary needs, all of that is all taught by my client, and she's been doing that. Instead, Mr. Higley, even when she was in maternity at an appointment, he basically he basically got in trouble with the doctor and had to be kicked out of a maternity checkup. Your Honor, both parties claim that their homes are unsafe or this, but I would say this, I'll leave that to the court's discretion, but there was testimony from my client that Mr. Higley's home is, 75 feet or 55 feet away from the highway on 69 and no neighbors close by. He's got a wood burner over there. She, if he's had people go to the home, parties, my client even had to leave that home for a little while because she couldn't keep up with the getting rid of the smell and the wood burning stove and that kind of thing. But she doesn't want her daughter in that party type atmosphere. And regardless, there was plenty of testimony, not just from my client about the parties and the things that went on over there during the relationship. We provided pictures of our home. We'd ask the court to consider those pictures as exhibits. While I would say I know that we had stipulated to some of the exhibits from counsel, so I would like her to make clear which ones we stipulated to if she hasn't done that already. Another thing that was concerning, Your Honor, about the home, about her staying in the home, was when he was gone for a line to join lineman training, was that he had gotten in a beer brawl or a bar brawl with somebody, and the person had came and threatened to beat him up. I think he's been kicked out of bars because of fighting, which is juvenile, but it also often happens with people that drink too much at bars and frequent these places a lot. He's also had a catalytic converter stolen out of his truck, is kicked in the front door of the shop, was kicked in. And my client, again, has never had these problems. And my client has never had a situation where, Oakley's been in any kind of danger in her care. So any statements that occurred would be completely false. Even in the care of her grandmother, absolutely no dangerous conditions and nothing happened. Your Honor, currently Heather and Oakley live in Mason, Michigan. Heather's father has offered that home. She plans on buying that at the conclusion of this case, if the court does decide to keep custody the same. Heather does not consider, his residence a home, Dale's residence a home for the reasons stated above. When it comes to moral fitness, Your Honor, I mean, again, there were so many episodes of things. It's just hard to keep track of it all. But I would say, and I'm just going to sum up here, the alcohol, anger, and domestic violence issues. He clearly lies about his drinking. And he's even lied in his own testimony and contradicted himself. But the statement that stands out in my mind is, I had to drink a few times to see if that's what caused my headaches when he testified the first time. I don't know if he's trying to convince the court that he doesn't drink too much because of his headaches, but I would say the headaches maybe are a result of the drinking or a hangover. I don't know. I'll leave that to court to decide, but it's got to be the most far out explanation I've ever heard from somebody with problems with alcohol to make that statement. And, draining down the keg September 29th. I mean, you've heard testimony about that. Tried to claim that my client drank 4 nights a week, but she breastfed Oakley for 3.5 years. And it was almost like hey, you're saying I drink a lot, so now I'm going to say you drink a lot. It was that kind of thing. With really no proof. even trying to go after the grandmother for drinking too much. And I think we dispelled that as well. The first time he testified too, he said that they broke up right after the accident, that she moved to the UP and basically left him. But all the witnesses, including him today, even said that that's not true. My client wouldn't do that and didn't do that. She took him to his neurology appointments, and even tried to give him articles relating to peaceful parenting and things of that nature. Your Honor, I think he's understated also his physical and mental health. He testified today about the epilepsy issue. He also testified the first time that he had a brain bleed, and then my client testified unrebutted that he had his traumatic brain injury as a result of the accident. He was in ICU. My clients, he testified that there was a lack of communication between the parties, but Your Honor, I would submit that all of the text messages and the examples that we gave of communication, that my client had to do that. She had to write it down because of his memory loss problems. And interestingly, one of his witnesses today said that he's had problems since the accident, but really wouldn't I say what it was, and just kind of backed himself off of that. But I think the court can read between the lines on that. Heather is not a doctor, but she did speak to the doctors. Your Honor, my client, when it comes to the home and school record, my client has testified that she did the easy peasy preschool curriculum. She did that on her own with Oakley, and found the Just Imagine preschool and did all that, and then consulted Mr. Higley, and he consented to that. Apparently, Oakley's doing very well in her school. And I would say there's testimony that if she continues to do well, there's even a kindergarten program right in the same building, in the same school. But Heather has also been looking into Montessori school options, which I think she's going to have to discuss with Dale at some point. And again, there's a lack of, until today, there was a lack of preference on education. Also, I think Mr. Higley testified doesn't really have any caregivers in the area yet. Heather has multiple family members in the area, including her mom. And Oakley has made friends, continues to make friends every day. Emma, Ella, Savannah, these are a few names that were mentioned. By the way, Heather supports Oakley involved in her extracurricular activities, soccer and gymnastics, including the activities including the activity, and I see him pointing to himself, and I was going to say, including the activities that Mr. Higley has her in, which I think is gymnastics. She is supportive of that. In fact, she has so much still, after all the abuse and everything and things that took place, she's still willing to encourage a good relationship with men, including in one of our exhibits, having him over the house to make slime or dinner or whatever they were making. Hopefully it wasn't the same thing. But that picture is of Mr. Higley cooking or doing something in the kitchen, in my client's kitchen. She Heather does not want him not to be involved. This is not an alienation case. She wants some involvement as a father. And she just wants him to, get ready to do things that he needs to do, to get over the drinking, to get over the lack of parenting skills, to change. My client also invited him, and I think the court asked questions about this, extra holidays, trick-or-treating, New Year's Eve, things of that nature. She talked about that. But going back just for a second, Your Honor, I would say, wrapping it up here, as far as domestic violence is concerned, there were episodes of Dale losing his temper on 11/21/20, the beer spilling incident. In fact, my client wrote a letter to him trying to get him to help him understand how this stuff impacts Oakley. Dale threatened not to spend time with Oakley and hung up on her in situations, called drunk, screamed and intimidated at her, telling her to get the F back in the bedroom. The peeing incident, other incidents. All of these things devastated Oakley, but also devastated Heather as well. The devastating effects on Oakley that needs to be addressed. So here, going forward, this is it, Your Honor. Heather wants Dale to stop lying about his drinking and stop drinking and attend AA and seek mental health counseling and not say disparaging remarks about her and Oakley and to other people in the community, which she believes is taking place. Because that doesn't really hurt her as much as it could potentially hurt the child. She wants him to complete a psychological evaluation if the court is so inclined, to be court ordered and court chosen. Heather wants to retain physical custody. And after the hearing today, after all these hearings, also wants full legal custody. The court made the right decision the first, when we were here back in, I think it was October. I'm sorry, there's so many dates, Your Honor, I can't remember, where the court granted my client physical custody. It should stay the same way. Right now, he's not prepared or ready to have this child in his care. And I believe deep down he knows it. Things need to change. And, you know, it's not a matter of, you know, oh, I just want to continue to live my life and drink. I'm an American citizen. I do this. And oh, by the way, I want my daughter too. It's a full-time job. It's a big job. And Heather has been the one to always do it and will continue to do that. So with those conditions, you know, going forward, that's what my client wants going forward.
Okay, thank you.
Thank you.
Ms. McNiff, anything else?
Your Honor, just that I would say that we did stipulate that my exhibit 1, exhibit 2.
Exhibits 1 through 5 were admitted by stipulation.
Correct. And I believe exhibit 8 was also one that Mr. Zoglio agreed to. I'm looking at the email that you sent to me.
Oh, correct.
And the one explanation for exhibit 5 is I think it says apartment. That's not accurate. Exhibit 5 is actually photos of my client's mother's home.
So my exhibits are exhibits 1 through 5, and counsel, you're saying exhibits 1 through 5.
No, you objected to exhibit 4, so it was actually you agreed to my exhibit 1, 2, 3, 5, and 8.
Five and 8. I think that's accurate.
Okay. Go ahead, Ms. McNiff.
That's all I had, Your Honor.
Okay, thank you. Well, in this particular case, as the attorneys know, that again, there are many issues in this particular case, as there often is, and obviously it demonstrates why we're here today. And again, but the court would note that even though there was conflicting testimony, court will find that the parties were really more considerate of each other than the court often sees, although they still pointed out various deficiencies. Also, I do note that some of the testimony was very self-serving, and that happens. It could be chalked up sometime to perception or simply trying to place themselves in the best light possible. But again, there was, conflicting testimony. The court would note that there was also significant testimony that the court didn't believe was relevant to the proceedings. But again, I guess that happens. Court notes that in any case, and especially in these types of cases, because so much happens behind closed doors, credibility is always a consideration in every case. Oftentimes, the parties will allege that the other party or their witnesses were not truthful or were lying, but the court has found that Inconsistencies in testimony does not mean that an individual has lied. The conflicting testimony can occur as a result of the witness's background, their perception, their bias, or the fact that they're understanding or misunderstanding or simply by mistake. When inconsistencies occur, the court will attempt to determine if they can be reconciled with other testimony or evidence. There was substantial, consistent, conflicting testimony in this case, and to a large extent, sometimes more, sometimes less than the court would normally see. The court will, however, assess the credibility of the witnesses and the evidence that is presented in this particular case. The court would note that as I go through the testimony, I'm not going to reiterate or address all of the testimony. The court simply can't do that, or we would be here another 3 days. As the attorneys know, custody cases are determined and governed by the best interest of the child test as delineated under the Child Custody Act, being MCL 722.23. And we will specifically examine each of the factors in a moment. However, the first task in any custody case is to determine if an established custodial environment exists. An established custodial environment exists if over an appreciable time, the child naturally looks to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the court can look at the age of the child, the physical environment, and the inclination of the custodian of the child as to the permanency of the relationship. The mere fact that the child's primary residence remains in one home is insufficient in and of itself to create a established custodial environment. And in this particular matter, the court will note as well that back on October 3rd, I believe, was the date that there was a motion, October 2nd, 2022, motion for temporary custody, which the court did in fact grant in this matter, and that order was not entered until February 13, 2023. The court will note that an established custodial environment is not created by an order, although it could create an order. It's important in that if a established custodial environment exists, it can only be changed upon a presentation of clear and convincing evidence that it's in the best interest of the child. If there's no established custodial environment, the burden of proof is by a preponderance of evidence. The legislature has enacted this burden of proof to minimize the prospect of unwarranted or disruptive change of custody and to erect barriers against removal of the child from an established custodial environment, except in the most compelling cases. The court, in going through the best interest test, will go over each of those factors individually. And the court notes that, again, the court does not consider best interest of the child test as a baseball box score where we simply add up all of the pluses, minuses, et cetera, and then we come to a conclusion. The courts have stated that the court has to consider all the relevant factors and evidence, and the court can assign different weight to different factors. The court will do so in this particular matter. First, we'll address the established custodial environment. Court would note that it does appear that both parties have been engaged with Oakley in this particular matter, although there has been different attention and different engagement of the parties with Oakley. Court will note first that testimony of both of the parties was that the defendant did nurse Oakley for a considerable period of time, and it turns out from the testimony that was approximately 3.5 years. The testimony of Terry Borden, the defendant's mother, that defendant was the primary care provider for Oakley, and that she had babysat Oakley for 2 times per week, and the defendant was always the one that would drop Oakley off and then would go to work and pick her up. Cassie Thalen, the defendant's sister, testified that the defendant was the person providing the care for Oakley, and that Oakley would run for her when she needs something. Testimony of defendant was that she was the primary care provider as well, and that plaintiff, between his work and hobbies, would be only home a few nights a week. She testified that she taught Oakley manners, that Oakley would come to her when she needed comfort, that she would, again, tell her when she was worried about things, that she was patient with Oakley, and if Oakley was crying, that the plaintiff was reactionary and would sometimes yell. I think the testimony of the plaintiff himself was that, again, Mr. McAlvin, that he had testified that, again, that if something went wrong, that the defendant would yell. The testimony of the defendant was that she works from home and that she was always available to Oakley. When I consider the factors that the court can look at to determine whether an established custodial environment exists, meaning the age of the child, physical environment, the inclination of the custodian, is the permanency, it does appear to the court in looking in this matter that because, the defendant did, in fact, was involved considerable period of time. She was nursing for 3.5 years. So obviously she was around the child all of those particular times. That the court does note that the plaintiff pursued lineman training where he was out of the home for, I think it was approximately 6 weeks. I could have that wrong. But that also that recently in the summer of 2022, he had a motorcycle accident where he was laid up and convalescing. He was in the hospital approximately 8 days. After that, his friend did come to take care of him for approximately 2 months, in which he was convalescing, and during that time was only available to Oakley on a limited basis. When I consider all of the testimony, not just what I've mentioned, but all the other testimony as well, the court in this matter is firmly convinced that the established custodial environment does exist with defendant mother. Therefore, again, to establish, to change in the established custodial environment, the plaintiff must show by clear and convincing evidence. Clear and convincing evidence is evidence so clear, so weighty, so convincing as to allow the court to come to a conclusion without hesitancy of the truth of the matters asserted in the case. So the court will be weighing the evidence on that particular basis. Looking at the first factor is the love, affection, and emotional ties existing between the parties involved and the child. We had testimony, of course, from both of the parties. Both of the parties had testified that Oakley loves the other parent, and there is no doubt based upon testimony of other witnesses. There was Jen Dye testified that Oakley loves the plaintiff. She has a good relationship with him. Blaine Lottenheiser, he testified that Oakley is plaintiff's primary concern, and he testified that he has no concern with plaintiff's parenting. Christopher Hugg testified that plaintiff tends to helicopter, meaning that he hovers over Oakley, but he testified as well that defendant was a good mother. Lewis Williams testified that plaintiff and Oakley have a perfect relationship, that plaintiff is locked in on Oakley, does not want anyone bothering him when he's with Oakley. But he also testified that defendant is very good with Oakley. Michael Martinez testified that both of the parties love Oakley, and it appears that she loves them as well. Plaintiff testified that he loves Oakley, and when he picks her up, times she'll run to him. And that in fact he has a good bond with Oakley, and he testified that she also has a bond with the defendant mother, and that they in fact both love her. When I look at the testimony in total, it does appear to this court that this factor weighs equally as to both parties, and that no party has an advantage as it relates to this factor. The next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, and continuation in the education and raising the child in a particular religion or creed. The court notes that Jen Dye did testify that plaintiff is a caring, a good dad. Lewis Williams testified he has no concern about Oakley's care by either of the parties and has never seen either of the parties yell at Oakley. Mr. Martinez did not see either party raise their voice in Oakley's presence, although clearly the parties both testified that when they had altercations or arguments between them, they were yelling, and Oakley was present at those times. The plaintiff testified that he goes to church every Sunday. He goes to Crossroads Ministries, where the parties had attended when they were together, and that he had Oakley in Sunday school. Defendant testified that she and Oakley go to church as well. The court notes that the defendant testified she was the one that located and enrolled Oakley in the preschool. And the plaintiff testified today that, he was involved in that decision and approved the preschool that she goes to at the current time. But the court does note that it was the defendant that, located that particular preschool. Defendant testified that she had acquired a car seat for Oakley and then purchased one and gave a different one to the plaintiff and installed it in his truck because she believed it was not installed correctly. She used the example of when Oakley had knocked over the car seat. The plaintiff obviously denies this, etc. When the court looks at, this factor, it's two things: the capacity and disposition of the parties involved to provide that. The court does believe that the parties all have both have the capacity, do have a disposition to do so, and as a result, the court will find that this factor does not weigh in favor of either party and is weighed equally. Next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, and other remedial care recognized in state in place of medical care and other material needs. The court notes that Ms. Dye had referred to plaintiff as a responsible party. Mr. Hugg stated that both of the parents were responsible. Mr. Sill said no concern about either party's ability to provide this particular material needs for Oakley. Testimony was of plaintiff and the defendant. The testimony of the plaintiff was that defendant provides the health insurance, that she also was the one that made the doctor's appointments and does not always notify him, and that he had recently taken Oakley to the dentist, and he testified today as well about taking her to some doctor's appointments, but not to all of those, that when they're routine, that those were left up to the defendant. Defendant testified that she was the one that would pick up the prescriptions if the Oakley needed them, that she was the one that cooked meals, purchased clothing, groceries, and that she was the one that paid for the preschool. There's no dispute about that or the other issue concerning the prescriptions. When the court does weigh all of this, and I'm not highlighting some of the testimony, but this wasn't all of it, that the court is convinced in this matter that this factor does weigh in favor of the defendant mother. Next factor is length of time the child has lived in a stable, satisfactory environment, and the desirability of maintaining continuity. In this case, the testimony of the plaintiff was that he'd lived in the Marshall area since he was 7 or 8 years old, that he owns 2 houses there. The current house that he's in effectively has been in since Oakley was born. The testimony that the defendant, however, has resided in different places. Again, Marshall with the plaintiff, that she then had a apartment or some for a period of time in Jackson. There was also testimony currently about that she's now residing in the Mason home, but has resided in Paradise and possibly another residence during the parties' relationship. The court notes, based upon the testimony, that this factor would weigh in favor of the plaintiff fathers. Next factor is the permanency of the family unit of the existing or proposed custodial home or homes. In this matter, there's testimony by the plaintiff that he is not residing with anyone, he's not dating anyone, and that is consistent with the testimony of the defendant as well. And so it doesn't appear either party has a significant other interest in this matter. As a result, the court will find that this factor weighs equally as to both parties. Next factor is the moral fitness of the parties involved. Oftentimes, in looking at the moral fitness, the court will look at either criminal convictions. Neither of the parties had testified, nor is there evidence that either of them has any criminal convictions in this matter. And there is no other issues concerning the moral fitness, except for maybe the issue concerning drinking. The court would note that, again, even though there was substantial testimony about drinking, which I'll get into later, court would note that the plaintiff doesn't have any drinking driving offenses, which oftentimes happen when an individual has a substantial issue with drinking. Although the court, again, I'll address this later as well, but when I look at this against all the testimony, the court will find that this factor is equal as to both parties. Next factor is the mental and physical health of the parties. The plaintiff testified he has no mental or physical issues, although he did testify he had some issues concerning some brain issues, and in fact had some seizures previous or prior in his history, and then he had a surgery, I think, when he was 18 in this matter. The court would note he was involved in a motorcycle accident on June 2nd, 2022, from which he is recovered. And there's no evidence at the current time that the motorcycle accident has, again, impeded his ability to care for Oakley in this particular case. There's also no testimony about the defendant that she has any mental or physical health issues, although I guess there was some stretch as to the fact that she had maybe fallen down, as he stated, once a year for the 6 years that they've been together, or he's known her, although there's been no independent evidence or corroboration of any particular issues. So the court will find that this factor does not favor either party and is equal as to both parties. Next factor is the homeschool and community record of the child. Oakley obviously is of a minimal age, being, I think she said she's 3, but close to 4. And I don't know if she just recently turned 4, but at least in the first hearing, it was that she was 3 and going close to being 4. But notwithstanding that, she doesn't have a school record other than the preschool. It's been testified that she does have friends at preschool that she does things with, residing in Lansing. There was a testimony as well that the parties both have had her involved in extracurricular activities. But there doesn't appear to be any community record, and the home record of the parties with Oakley appears to be pretty consistent and pretty, again, equal as it relates to both of the parties in this matter. The court does note one thing that the court, in looking at the school and noting that she is in the preschool, which the defendant located, although the parties had agreed. But the court does note in this matter that the defendant does have a bachelor's, has her master's in this matter, works for Michigan State University, that education is important to her. Court will note that the plaintiff did not complete high school, as he stated, because he had this surgery just prior to graduation. And in fact, that when he came back, there was a brief period of time before the end of the school year. And as a result, he just pursued employment in the job that he had at that particular time. So it does appear to the court that education is more important to the defendant than the plaintiff. The court will find that this factor does favor the defendant mother in this particular case. Next factor is a reasonable preference of the child. If the court considers the child be a sufficient age to express a preference, the court does not believe she is of sufficient age to express a preference, being only 3 years old. And so the court did not interview her and would not consider preference in this particular matter. The next factor is the willingness and ability of each of the parties to facilitate and encourage a close and continued parent-child relationship between the child and the other parent in this matter. The plaintiff testified that often they'll call Oakley in the morning and at night, and sometimes the defendant does not allow him to speak to her or not allow her to answer. He states he allows the defendant to call Oakley at night and that he is willing to encourage a good relationship with the defendant. The defendant has allowed plaintiff additional time. There were 2 occasions where they referenced and where the plaintiff acknowledged that she had provided him with some additional time. It does appear in her testimony that the parties had been more flexible in changing days or something of that particular matter. Court would note that oftentimes the defendant would call the plaintiff the very day that she wanted to change or allow him additional time. And he has testified that he's not available being called that day because they're on work sites or things of that nature. The court did find that some of these times that were being offered by the defendant were illusory and really were not an accommodation, because it was only an veiled attempt at cooperation when she realized, and if knowing the plaintiff's schedule, knowing that he couldn't again simply drop everything that he was doing at the job site he was on and in fact attending those particular days. So the court would consider some of that simply self-serving testimony to make her appear more reasonable, more conciliatory, when she reasonably could understand that he was not able to drop everything. But notwithstanding that, it does appear that the parties have been willing to work with each other and facilitate a relationship with the other party. As a result, the court will find that this factor weighs equally as to both parties. Next factor is domestic violence. Regardless of whether the violence was directed against or witnessed by the child, the only domestic violence that the court notes, in fact, the court heard the testimony of Mr. Williams. He said he had heard both parties swear at each other. Mr. Still had testified that on occasion he'd been at the restaurant where the defendant had been screaming at the plaintiff. However, it does appear that both parties acknowledge that time to time they've had arguments and they've been yelling at both parties. The court will therefore not find this factor to weigh in favor of either party, but be equal. Next factor is any other factor considered by the court as relevant to the particular child custody dispute. Again, I'm going back to, there was a lot of testimony about the plaintiff's drinking. Mr. Williams testified that both parties, he had seen both parties intoxicated, that he had seen the defendant and her mother drink a bottle of wine when he was at the restaurant. Mr. Still had testified that he had seen defendant making mixed drinks, making Jello shots, and that he had testified that plaintiff drank more when he was younger and not as much recently, and that after the accident, he had not seen the plaintiff drink as much or drink around Oakley. Mr. Martinez, who is a recovering alcoholic, said he has not seen either party drink too much, and he's never saw either party intoxicated, which is inconsistent with his testimony as to why he would have recommended the plaintiff for AA when he stated he'd never seen either of them intoxicated. Plaintiff testified that after the accident he had drank, but it did cause him to have migraines, and therefore he would not drink. And he said that he would never drink when he had Oakley with him. He testified that he quit smoking marijuana when Oakley was born. However, the court does note the testimony of Timothy Esser and Gretchen Esser, who were neighbors that lived across from the plaintiff's mother's home. And they both testified that on September 3rd, 2022, which was after the plaintiff's accident, they saw him intoxicated to the extent that, as Miss Esser stated, he urinated in the front yard and had to be driven home. It could be challenged, and the plaintiff did attempt to and state that this had not occurred, but the court does find both of the Essers to be objective witnesses that were not involved in this matter. There was no reason for them to, again, give testimony favoring one party or the other, because, again, neither of them had, again, a dog in this fight, so to speak, and the court finds their testimony to be credible and to find that the plaintiff was intoxicated on this particular evening. Terry Borden testified that plaintiff had a drinking problem, that he would drink every day. However, she did testify at the last couple of family get-togethers that the plaintiff did not drink. The court does note that in this particular matter, as I stated, neither parties have any convictions for drunk driving or anything of that nature so the court takes that into consideration. But it does appear that the plaintiff has, again, structured his life a little, if you would, around drinking, where he would go to, again, the pool league nights where he would watch, his friend play pool, that he would drink some. The defendant testified he'd come home intoxicated. There wasn't anything other testimony about that other than her, and maybe she was more sensitive to it based upon the history in this particular matter. But the court does note that even that testimony was that at different times when they were at U of M games, that either that or when he would golf, that he would in fact drink. In this matter, that Mr. Sill had testified that during the times they did golf, that each of them would have 3 beers during the round, and then they'd have last call when they finished, and that in fact he had various parties watching football when Michigan played or when he was at the Michigan games, and that all of these events that they would involve, again, drinking. And so the court finds that to some extent, he's structured his life around those particular events, and that even though, again, the court can't say it's a problem, he's really been involved and engaged in this kind of behavior. The court notes that the plaintiff has testified that he does maintain season tickets at U of M games and that he golfs, and the defendant found fault with this, but the court would note that, again, it's apparently an attempt to establish that he couldn't care for Oakley, but court would note that both of these activities could involve and enrich Oakley's life when she's older. And again, Court would note that there's no requirement that a party become a monk when they have children, that they can still engage in and have other hobbies and activities that, again, could be enriching to the child as the child gets older. The court would note that each of the parties have raised multiple other matters that the court does not consider relevant in this particular case. And as a result, the court has discounted those, but the court is taking into account, again, the drinking as a issue in this particular matter. Testimony was even today that the plaintiff, again, did maintain a keg at his residence for approximately 5 years. And that, in fact, after work, that many of the workers and that they would come back to the house, they would drink. And again, it would establish that the plaintiff was not available to Oakley at these particular times. When I consider all of these other factors that the parties have brought up, the court is of the belief that this factor L, other factors would favor the defendant mother in this particular case. When I do this, and I look at all of the factors and all of the evidence in this matter, the court does note that the plaintiff, well, let's put it this way, the defendant has established that, at least by a preponderance of evidence, that it is in the best interest of the minor child that Oakley be in her custody, at least for physical custody. The court would note that the evidence presented by the plaintiff in this matter to change the established custodial environment is required by clear and convincing evidence. The court finds that he has not established, even by a preponderance of evidence, that it's in the best interest that he have custody. And as a result, the court is going to grant physical custody to the defendant mother in this matter. The court is required to, in looking at custody, is required by MCL 722.26a to consider whether the court would look at joint custody. And in this particular matter, as I stated, the court has found that physical custody should be with defendant mother. But when I look at legal custody, the issue is, can the parties agree on and discuss important matters concerning the child? Again, the parties have shown that with the preschool, in which they have discussed that, and they have agreed that there has been time where the parties have addressed the issue of the doctors, dentists, things of that nature, that they have agreed as well. Although they have been able to discuss, based upon all of the testimony, the court does believe it would be in Oakley's best interest that the parties would share joint legal custody in this particular matter, so the court will order that. Next, the court has to look at issues concerning parenting time, pursuant to MCL 722.27a, and I have to look at the various factors. The first factor is the special circumstances or needs of the child. The court does not find that the child has any special circumstances or needs, so the court will not weigh that factor. Next factor is whether the child is nursing. The child is not at this point, and so the court will not consider that factor. Next factor is likelihood of abuse or neglect of the child during parenting time. The court will not find that there is any likelihood of abuse or neglect during parenting time in this particular case. Next is likelihood of abuse of a parent during the exercise of parenting time. The court will not find that and does not find that the evidence does establish that. Next factor is the inconvenience or burdensome impact of travel on the child. The parties live approximately less than 50 minutes apart from Marshall to Lansing. Court does have substantial periods of time where the parties can be in adjoining communities and be at least 50 minutes apart. And as a result, the court finds that there would not be an inconvenience or burdensome impact of travel on the child for purposes of parenting time. Next factor is whether a parent reasonably expected to exercise ordered parenting time. The court does believe that the plaintiff would exercise all of his court-ordered parenting time, as he has since the temporary order was entered in this particular matter. Next factor is whether parents frequently fail to exercise parenting time. There's been no testimony that he's failed to exercise parenting time, although that time has been changed. Based upon all of the factors that the court weighs as it relates to parenting time, the court has to fashion a schedule whereby we can facilitate and encourage that parent-child relationship in this matter. After considering that, the court is going to grant to the plaintiff parenting time, which would again occur on the first 3 weekends of each month, from Friday at 6 o'clock p.m. to Sunday at 6 o'clock p.m. Standard midweek on Wednesday for the 4 hours, or at the time that she's in school from after school until 8 o'clock p.m. if the parties can work out that. Again, they'll have to do it with transportation, so it wouldn't be immediately after school unless he chooses to pick Oakley up from school and then have her back at 8 o'clock. Court would also implement the standard Calhoun County holiday parenting time, alternating holidays, alternating spring break, 1/2 the Christmas vacation period, 1/2 of the summer vacation period, and alternating weeks in this particular matter. Court next have to consider and determine amount of support that should be paid in this matter by the plaintiff. He testified that his gross income was anywhere from $37,000 to $39,000. Court would note that if he was simply working and making $15 an hour, that would equate to just over $31,000 per year gross. So the court is going to, for purposes of calculation of child support, take into consideration and weigh for the plaintiff a gross yearly income of $37,000 per year. The defendant testified that her gross income is $46,000 per year, that she also is responsible for, and she does pay the healthcare insurance for Oakley. So the court would take her income of $46,000 gross, less again the healthcare insurance portion attributable to Oakley in this particular matter, and then take that into consideration with the parenting time that the court has just ruled in this particular case. With that, the court believes I have addressed all of the matters before the court today. I will ask Ms. McNiff, is there anything else that the court has failed to address or needs to address before we conclude?
No, Your Honor.
Okay. Mr. Zogli, is there anything that you believe the court has failed to address or needs to address before we conclude?
No, I mean, I think we had requested some anger management classes or some disparaging, not allowing to make disparaging remarks about the parents.
Yeah. Well, that's the disparaging remarks part is part of the inalienable rights of the child, and so the court's not going to simply reiterate that. I know it's been requested by various things. The court does not find that the evidence established in this matter justifies any sort of other counseling in this particular matter, so I'm not going to order that in this particular case at this time.
Okay.
With that, I'll ask Ms. McNiff that you would prepare the appropriate judgment and orders in this matter and submit those to the front of the court for approval, submit them to Mr. Zoglio, and then we'll get this matter concluded. And I want to wish each of you the best. I hope everything works out. And the court will conclude this matter at 11:52 a.m. You're free to go. Have a good day.
Weird. It is 11:44 p.m. where I am, not 11:52. Oh God, that was not very pleasant. I don't know why we do this to ourselves. I think we just love it. We get into it and we're like, "Hey, if they're gonna sit through it, we're gonna sit through it." Um, he did get more than the standard visitation. He was the plaintiff in this case, which I think is also really important to note. Um, I don't think his lawyer did him very well. I think the other lawyer, as annoying as it was, like his lawyer should have been objecting constantly to the beer and keg and stuff. Like most of the testimony was just absolutely irrelevant. And a better attorney would have been objecting to it and making the judge rule on it and making it not fly. And instead, they just let that go on. And there may be a little bit of a wide berth given, but not prior to the actual birth of the child. Like that's not what they're going to take into consideration. So, he, I think it was not what, but again, and here's the thing, guys. You saw what it's like in real life. This is how court hunting is. Sometimes you don't get to see every part because of this, that, or the other, or Miss McNiff's stalker. Also, don't stalk people. Just as a reminder, please don't stalk people. I know you guys wouldn't, but um, don't do that. Um, yeah, I really wish, sometimes I often think about, hey, what if my other favorite judges had taken this case? So, like, Judge Manning would have just ripped her hair out. Judge Webster from Texas, again, would have, like MB said, would have dealt with this by humming in 45 minutes. And, um, I'm trying to think of other judges. Like, it's just, I don't hate this judge. I like this judge in a lot of cases, but sometimes I think to myself, who's, it's get bad when the judge sort of makes objections for the lawyers that they're not making. Like, that's a bad. And to be fair, we've probably watched a lot more real court than some lawyers have because they were like busy going to school, becoming lawyers and stuff. And we've just been watching YouTube. So, like, I've put in my 10,000 hours of court easily, easily. And and that's a lot more like experience and exposure to actual trial than most people get in even lawyers. Because if you're a good lawyer for the most part, you actually don't go to court that much. You negotiate and stay out of court, unless, again, you're a trial lawyer, but those are sort of different. What happened was Zoom became everybody was a trial lawyer because we were able to see all the hearings, Um, what we know is that each judge, what I think is most important when you come to court is knowing who you're in front of. That's really why you want to hire a local lawyer because they know the judges and they know the decorum of that court. Sometimes the rules and the law are really not what's most important. It's what your lawyer or who you are knows in front of the judge and how to act. It's the same in Judge Kim's court. It's the same in front of Judge Manning. I mean, there are a few small things that can get you in a very good place with a judge. So it's, that's what most lawyers you're paying for when you go in front of them. And that's why sometimes when we see lawyers that are so obtuse, they don't catch like, the the freaking signal flares that are being shot out by the judges. Um, you know, that I always wonder, I'm like, what were you doing in school? Like, But again, in law school, there's always going to be somebody graduating top of the class and somebody graduating at the bottom of the class, but they both get to call themselves lawyers. So that's not really, what you get to pick from. um, anyways, I think that it was a bit weird. I don't think that's exactly how I thought that would turn out. But again, we didn't see in the entirety of it because we couldn't. Um, what was I gonna say? I'm trying to recall here. Oh yeah, guys, please go ahead, like the video if you haven't already. I know most of you have. Um, and yeah, the child is losing here. What I would really like is the judge should have immediately ordered the use of a parenting app in this case, that records and tracks their scheduling and conversations. That should have been immediate. And it's a no-brainer in reality because that app, even without a GAL in place, if you make them use that for communication, when you later have to review the case, you can have the data. And so if you have one or both parties who are not playing fair, requiring communication through a parenting app is very, very telling because either they'll use it and just overtly be rude and like not appropriate in the app, or they'll refuse to use it. That's something we see quite often. Oh, I can't download it. Oh, I didn't know I had to. Oh, I just text anyways. And and that's in itself just as telling as if you were to use the app improperly, in my opinion. Um, the whole point, it's almost like being on in a detention facility, like with the juveniles. When you are not being a good parent and you have to go in front of the court, the parenting app is basically monitoring your behavior and ranking your levels. And your behavior, it's very easy. The expectations are extremely clear, and it's really, really not difficult not to mess it up, but yet people can't stop themselves. um the poll, let's see, let's go over that one here. We'll end that poll. Let me see. Who do we believe? Dad 38%, me 28%, none of the above 26%, mom 6%. And I think that's fair because we didn't hear from mom in full. um I wish we could have, but we get what we get and we don't get upset. Um, Thank you for the reminder, by the way, Mayor, for that. I honestly think that this is just a sad situation for the kid in the end because the parents need to be able to put her needs truly first. And I didn't hear much about this kid at all. In the other divorce hearing, at least those people we were hearing about the therapy they were putting the kids in and all this kind of shit. We really didn't hear much about Oakley other than where was she while you were drinking? That was mainly the question that we heard asked. And again, nothing that they alleged was illegal and not even like that off base for most average people. I think the lawyer, a better or a different tact might have been to go directly into um like I just don't understand the why they did that the way they did. Like to me, this case was overboard. Like I don't know who scheduled this. What type of cost it had for these people. It's obscene. Obscene. Um And keep in mind, this is not our standard custody case. These are a plaintiff and a defendant. So a civil custody case. This is not brought by the Attorney General's office, which are what most of the court cases with custody we see. where they assign child support amounts, etc. So those ones are lawsuits that are brought by the attorney general because the one of the parents is collecting benefits usually, and that's what triggers the other parent to be asked for child support. This, however, was the dad as the plaintiff coming after the mom as the defendant to, I guess, well, there was no legitimation mentioned, so I guess he's on the birth certificate. I guess just to exercise his custody and to formalize their custody arrangement. Where I'm from, you are required to attempt mediation before you would be allowed to go to this type of hearing. In good faith, like absolutely required to do that. And I really feel like they both could have got a better deal out of this if they had gone through a mediator and spent some of the money they spent on lawyers on having fun with their kid and doing some new things, and learning to be independent parents and a new way of life going forward. The hard part about divorce is that you can't always see that when you are in the middle of it. As kids, you don't realize that parents and adults are just as infallible as kids. Some kids have great role models who they believe can do anything, and other kids don't have that. But when you grow up, I remember when I had my daughter in my arms for the first time, and I was only 20 years old. And I remember thinking, oh my gosh, oh, this is real. This is happening right fast. And like, there's no actual manual. I mean, there's lots of books, but nobody, none of them are official. Like there's no and as you become a parent and as you become more and more confident, you learn about those things. But it's hard to teach or explain. And honestly, I think that they probably had a decent first couple of years where she was very attached to the child, breastfeeding all the time. He was out doing things with his friends, happy, whatever. But she obviously wasn't, she was writing in her journal, but she wasn't telling him what was going on. And, this is what happens, I guess, when there's breakdown in communication as well. It's hard, but they hopefully will realize that they're better going forward as a team. And I hope that Oakley will be able to thrive and bring joy and happiness to both of their lives. And that they can learn to see that and not worry about the other parent. Um, I think that, like, something I learned later on, um, that I used to say to my daughter without being trying to be mean at all, but I used to say to her all the time, "Oh, you look just like your dad when you do that." And I read or like somehow learned later that once you're divorced and like you've made a really like declarative statement, like me and your dad are no longer together. I don't quote unquote like him anymore, or we're not together anymore. When you don't know how kids internalize that, and you have to be very careful because they can take something like, oh, you look just like your dad, as, oh, I don't like your dad, therefore I don't like you. And I had never thought about that because I don't not like Peyton, or sorry, my daughter's dad. I I just don't have ill feelings for him. He's her dad and I love him for that, but we're not together and we'll never be together. But I think that it's hard to recognize that some kids might not realize that because they're kids, and some adults might not actually have that, where they truly have some hate in their heart for somebody else. So it doesn't come across nicely. Anyways, so They are half that person at the very least. And they also, like, kids grow up and they remember. Even if you don't think what you were saying was snarky, kids get it. They know snark, they know underhanded stuff. And so you can play that role when they're young all you want. And yeah, they will listen to you. But believe me, there will come a day when they, as an adult, look at that behavior and may find it a little bit abhorrent that you weren't able to lift yourself above that for a child. And that's, um, you know, hard to do all the time, but what we all strive to do. Anyways, it's med check for everybody. This is a reminder to check for your meds if you need them for tonight. We are almost done for this evening. I love you all. It's been a long one, but I've enjoyed it. I will be looking for some new fun court for us to watch this coming week. It's Cook Week. Please don't forget. You will be seeing me from a new kitchen, and we will be having day and evening streams along with special story time, special recipes, and much, much more. So, mark it on your calendars and make sure to drop by. I hope you guys have a wonderful evening, and I will see you soon. Okay, bye.